My objective would be that I should tell you that how the question has to be attempted. I should also teach you 13 to 15% questions come from the polity only. So obviously we cannot. Now constitution of the country, as you know, what is the chief purpose? Law has to be fair, law has to be reasonable. This is called as First Amendment Act. First Amendment Act came in 1951, obviously at that time. So fundamental duties are not legally enforceable, like they are not the legal obligations. In fact, hello everyone, this is me 𝐂𝐿𝐶𝐃𝐄𝐂𝐿. I welcome you all to PW UPSC Wala English. So friends, as you know that we have very limited time for Prelims 2025. So this is where PW has decided that we should come up with PYQs. We should at least discuss certain PYQs for you, so that by the time you are giving the examination, you are through with the PYQs, and by solving PYQs here, you would be able to understand that what is wrong in your preparation and how it can be rectified in the next few 2 weeks, 2 or 3 weeks, whatever is the time. So this is where I would be discussing the polity PYQs, I will be discussing the PYQs of previous 10 years, and my objective would be that I should tell you that how the question has to be attempted. I should also teach you what kind of trend has been followed, so that in case if there is certain kind of lacuna still left or something still left in your preparation, you would be able to go through it. Now, before coming to that thing, I just want to tell you that I think I don't need to tell you that polity happens to be one of the most important subject of the examination. Why? Because if you will see the trend analysis, you will find that almost 13 to 15% questions come from the polity only. So obviously we cannot skip it, we cannot discount it. We have to take advantage of this particular paper, because if out of 15 questions, if you have done things thoroughly, if you have been the student of classroom, or if you have done it properly from anywhere, you should be able to secure at least 12 to 13 correct questions. Now, having said that, let us start the questions. And the questions are being arranged in the chapter wise. First, we will be going with the historical topics, then fundamental rights, so on and so forth. So first question is, who was the provisional president of Constituent Assembly before Dr. Rajendra Prasad took over? So as we all know that B.R. Ambedkar was not the case, Rajgopalachari was not the case. Obviously, Dr. Sachidanand Sinha was the first one. Okay, so he was the one who started this. Okay, who basically was the provisional president before Dr. Rajendra Prasad was elected. So in the Constituent Assembly, the meeting convened on 9th of December 1946. So according to the French tradition, Sachidanand Sinha, the eldest member, he happened to be the eldest member, was chosen the interim president of the assembly. So he was elected as assemblies. Later on, the Dr. Rajendra Prasad was elected as the assembly's president. Now, on 11 December 46, assembly held an election for the permanent president, and this is where Dr. Prasad was unanimously elected as the president of the Constituent Assembly. And in fact, his name was proposed by Jawaharlal Nehru, seconded by Patel Sahab, and ultimately he was elected by the assembly. So I guess not just the question over here, you should also focus upon the content written in the slides, because this would definitely help you in cracking the questions. Let us say the same question is not being repeated, but something from these facts would be coming in examination. So you should go through them. Now next is, by which of the following acts was Governor General of Bengal designated as the Governor General of India? It was asked in 2023. So the Charter Act of 1833 is the right answer. These questions have to be done factually. The facts should be on your tip. Okay, why? Because if you'll see that the question is saying that Governor General of Bengal is being designated the Governor General of India. So what is going to happen? The centralization of powers are going to happen. So obviously when centralization of powers are going to happen, then 3033 is the right act. It all started with the 3033. So if you could see this, that it was the final steps towards the centralization of British India. It made Governor General of Bengal as the Governor General of India, and civil and military powers were vested under him. It was given to him. In fact, it also deprived the governors of Bombay and Madras of their legislative powers. This act was nothing. This act was taking the territorial control by the British Crown. The Crown is now would be coming up and would be taking the government over, or would be taking over the government. Laws made under the previous acts were called the regulations, but now they would be the charters of the crown. In fact, it also ended the activities of East India Company as commercial body, which now purely became a administrative body. Fine. So again, these are very factual things. Next, consider the following statement in respect of the Constitution Day. Constitution Day is celebrated on 26th November every year to promote constitutional values among citizens. Okay. Then 26th November 1949 is celebrated. The Constitution of India set up drafting committee under the chairmanship of B.R. Ambedkar to draft something. So both statement 1 and 2 are correct. Correct explanation. 1 and 2 are correct. 2 is not the correct explanation. 1 is correct. Second is wrong. So 26 November 1949 we are adopting the constitution. So obviously this is where the answer would be first is correct and second is not correct. Okay. So second drafting committee set up under chairmanship of Ambedkar on 26th August 1947 to prepare a draft. 26 November 1949, it is the date written in the preamble that we have given to ourselves this very constitution. So we are adopting this constitution. Okay. So these questions are simple. As of now, they are simple. Next comes question number 4. In the Government of India Act 1919, the functions of provisional government were divided into reserved and transferred subject. Which of the following were treated as the reserved subjects? So this is again a very simple question, that if you will see that we are dividing the functions into the reserved subjects and the transferred subjects. As the name suggests, reserved subjects. Look, if you will see the current system of federalism also, the most important subjects are with the central government. Reserved. Reserve means the subjects are not to be given. Not to be given. Now, if you see local self-government, administration of justice, local self-government, land revenue, police, which among the following is the least important power over here, least important subject over here? Obviously, local self-government is the least important, not so important, I would say. So, if we'll apply this, then we are able to figure out the right question over here. So, 1, 3 and 4 obviously, or otherwise if you'll see, police happens to be the most important, then you would be able to eliminate A part, then obviously you are eliminating the B part, 2, then 3, because 2 has to be eliminated. So this is where the answer would be C. So let us quickly recap the powers over here. So the Government of India Act 1919, so it introduced the concept of diarchy. What is diarchy? Diarchy is nothing but division of the subjects between two different bodies. Now, it divided subjects into 2 categories, the reserved and the transferred. Important subjects like law and order, land revenue, administration of justice, finance, police are to be controlled by the governor, whereas the transferred subjects like education, health, local self-government were to be managed by the ministers, or they are elected from the legislative council. So, aim was to increase the Indian representation on the lower side. So, now Indians would be considered important, or Indians would be taking care of their powers with regard to health, local self-governance, etc. I guess this is done. Next comes some basic concepts. Which one of the following statements best reflects the chief purpose of the constitution of the country? For what sake have we created the constitution of the country? Now, constitution of the country, as you know, what is the chief purpose? The chief purpose of the constitution of the country is to devise or is to identify the powers of the government. Keeping this in mind, let us now solve the question. It determines the objective for the making of the necessary laws. It enables the creation of political offices in the government. Obviously, it does that. It defines and limits the powers of the government. It secures social justice, social equality, social security. Even if this can be leveraged, this can be removed, but no. Constitution promotes constitutionalism, and constitutionalism is nothing but limiting the power of the governments. Constitutions have been written so that governments are not highly powerful. The governments would be here limited by their constitution, and government would not be able to do something which the constitution doesn't allow. If you could recall Article 13 of the constitution, Article 13 of the constitution says the same thing. But exactly it says that your fundamental rights cannot be compromised. Any law of the parliament cannot compromise your fundamental rights. That means in certain principles, in certain ways, the constitution is above the government. In fact, if you could recall the cases like IC Golaknath case, in fact, in IC Golaknath case, the court held the constitution cannot be changed by the parliament. So obviously, the constitution over here is nothing but a document which ensures that what shall be the powers of the government. So constitution is a body of basic laws. Even the private organizations can also have the constitution. It tells us that how the state has to function, what fundamental principles we have to follow, what are the norms, powers, institutions. Okay, it also talks about what kind of country we are. But on and on, the most important, the chief purpose is that it provides that how the powers of the government have to be made limited. Clear? Next comes, in essence, what does due process of law means? Now, the term due process of law was never put up in the Indian Constitution. If in fact, Article 21 talks about procedure established by law. So, procedure established by law is a British concept. We have taken it from the Britain, and due process of law is the US concept. In USA, they follow due process of law. This due process of law gives power to the judiciary to check the laws of the parliament, where they just need to check whether the due process has been followed or not. That means while implementing any law, whether the parliament has taken care of the fundamental rights. And this is where in Maneka Gandhi case, the court said that the golden triangle has to be checked whenever you are passing any law. Make sure that law does not infringe Article 14, 19 and 21. That means law has to be fair, law has to be reasonable. This is called as due process. Whereas procedure established by law says if parliament has power to pass something, parliament can pass that act. Now the question is, in essence, due process of law means, what does it mean? So it means the principle of natural justice, the procedure established by law, fair application of law, equality before law. So obviously, it is nothing but principle of natural justice. So principle of natural justice applies over here. So let us see the answer. The doctrine has its origin from English. Common law, it was first seen in the Magna Carta. Fine. The due process of law doctrines examine not only whether law exists, deprive a person, but also whether it is fair, just and not arbitrary as it was held in Maneka Gandhi. So unlike procedure established by law, so this is where the due process of law says that not just the procedure, you have to pass the reasonable laws, and A is the correct answer. Mark A is the correct answer. Fine. So all complete Article 21, expansion of Article 21 is nothing but the part and parcel of due process of law. Next. Which one of the following best defines the term state? A community of persons permanently occupying a defined territory, independent of external control and possessing an organized government. So obviously state, if you could recall the definition of state as per the political science, state has four important features. It need to have a population, it need to have a territory, it need to have the government, and it need to have the sovereignty, the power of the government. These are four important features of any state. Now the question is, which one of the following best defines the term state? How will you identify whether something is state or not? It is a community of persons permanently occupying a definite territory, independent of external control. Obviously sovereignty is there, citizens are there, okay, the government is there, territory is there, population is there. A politically organized people of a definite territory. Politically organized is not important. Okay, number of persons who have been living in a definite territory for a very longer time with their own culture, tradition and government. This can be the definition of nation. When you have one single culture across the territory, then it is called as nation. Whereas state is a political entity, so it is nothing but a community of certain people. Society permanently living in a definite territory with central authority. There is no guarantee that State should have a central authority, it should have population, it should have territory, it should have government, and it should have sovereignty. Done with this? A is the right answer. Now, which one of the following factors constitute best safeguard of liberty in a liberal democracy? So, how are you going to protect liberty in a liberal democracy? So, a committed judiciary, will a committed judiciary ever be able to save you? Committed judiciary means that whatsoever the government is doing, the judiciary is approving it. So, that means the judiciary and the government have come into collusion. It has defeated the concept of checks and balances. A centralization of power, there is no guarantee that centralization of power will provide you any kind of liberal democracy. Elected government, can you make sure that elected government will not take away your liberty? The elected governments have taken the liberties. And then separation of powers. So, which of the following factors constitutes the best safeguard of liberty? That means where the powers have been separated among the different branches. So, separation of power is the right answer, the most appropriate answer. The doctrine of separation of power. What is separation of power? Montesquieu gave the concept of separation of power. Why? Because the power was concentrated only in one authority. King was the judiciary, king was the legislature, king was the executive. So this is where Montesquieu wanted that power should be separated in three different branches. Why? It will remove the concentration system, and it will also ensure that not one person become highly dictatorial. When power is concentrated in one person, so that means absolute corruption shall happen. And this is where he wanted that demarcation should be there. So demarcation prevents the concentration of excessive power. No one shall be having excessive power over here. Okay, so D is the right answer. Article 50, it's also a DPSP. If there comes a question, how many DPSPs have been achieved so far? Article 50 have been achieved where we have separated judiciary from executive. In British times, the judiciary and executive used to be on the same platform. Now they have been removed, but they have been separated. So committed judiciary, obviously centralization of power, elected government, this we have discussed. What is the position of right to property in India? Look, right to property, there was a trail of cases where right to property from being a fundamental right was first made a limited right. If you could recall the First Amendment Act. Why First Amendment Act came? Because in Kameshwar Prasad, the High Court of Patna said that property is a fundamental right and you cannot take away the property. You cannot acquire the property of the zamindars. So where the Bihar government wanted to pass Zamindari Abolition Act. Now, so then what happened? Then 19(1)(f) was made a limited right. Earlier it was a fundamental right. It was made a limited right, and after 44th Amendment it was removed, and 300A was added as a constitutional right. But despite of being a constitutional right, the land remains a state subject, and state governments have power to regulate the land policies in their state. So it's a legal right available to citizens only? No. Legal right available to any person? Obviously, legal right available to any person. Fundamental right? Not at all. Neither fundamental nor legal. No, it is a legal right available to any person. Let us say if you are not the citizen of India, you can buy land in India, provided the state laws allow you. For that, for example, recently the Uttarakhand government has passed a law that a non-Uttarakhandi cannot buy the agriculture land in Uttarakhand. Similarly, if you are an NRI, if you are a non-Indian person, if you are if you are not the Indian person, if you are a PIO holder, if you are having the passport of any other country and you want to purchase land in India, you can purchase all sorts of land except agricultural land. So a non-citizen in India cannot purchase agricultural land, and whereas various state governments prohibit the outsiders to purchase the land. So that depends from the demography of the state. Himachal does not allow, tribal areas of Himachal it is not allowed. Then in Uttarakhand now it is not allowed, Northeast not allowed. So that vary from state to state, but we can say that it's a legal right available to any person. That means a foreigner can buy a parcel of land in India. So originally Indian Constitution recognized it as a fundamental right. Later on, it has been converted into a legal right available to any person. One common agreement between Gandhism and Marxism is, obviously. Okay, so this is again, these kinds of questions were not expected, but these are very generic questions. Okay, we can solve these kind of questions from our day-to-day understanding, day-to-day, because we have been reading a lot many things in newspapers. If you are from PSI background, things would be easy for you. One common agreement between Gandhism and Marxism is final goal of stateless society. Obviously, both are anarchist. Gandhi was also called as anarchist, so is Marx. Marx wanted that state should be removed because state is the means, is the exploitator. State exploits. So that is why he wanted to remove the state. Gandhi wanted to remove the state. Why? He focused on the stateless system, because Gandhi was of this view that in Ram Rajya, state would not be required. People would be able to take care of their own. So we do not need any kind of state. Class struggle is never the idea of Gandhi. Abolition of private property, never the idea of Gandhi. Economic determinism is purely a Marxist concept. This remains the common concept. So let us see what is the answer. Common agreement between Gandhi is the final goal of state. Again, both have their own reasons to remove the state. Gandhi was in favor of Ram Rajya. He was like, now we will have a virtuous society, social order would be there, hence we do not need state. And Marx was of this view that state is nothing but a means to exploit the poor section of society, the proletariat of the society, hence state should be removed. Now, in the context of India, which one of the following is the characteristics appropriate for bureaucracy? Which is appropriate for bureaucracy? It is an agency for winding the scope of parliamentary democracy. Okay. Agency for strengthening the structure of federalism. Agency for facilitating political stability, economic growth. No. Widening scope of parliamentary democracy. In fact, if you will see, in presidential democracy also you have bureaucracy. So this is a wrong statement. Agency strengthening structure of federalism. Not at all. Implementation of public policy. Bureaucracy and public policy go hand in hand. So you can always see that whenever the term bureaucracy would come, the task is to implement public policy. What are bureaucrats for? They are the permanent executives. Their task is to implement the laws of the parliament, the laws of the ministries, whatsoever laws have been passed. So it is an executive branch responsible for implementing decisions made by the elected officials. Now, in the context of any country, which one of the following would be considered as its social capital? Again, this is not a polity question, but again, this can be taken as a polity question. Which of the following is the social capital? Proportion of literates in the population, stock of its buildings, other infrastructure and machines. No, it is for GDP. The size of population in the working age group, it is demographic dividend. And the level of mutual trust and harmony in the society, this is the social capital. So let us see what exactly social capital term defines. So OECD says that social capital can be defined as network with the shared norms, values, understanding that facilitate cooperation within the groups. So this is called as social capital. So this kind of population ensures that the nation is is able to take the benefit of its resources. Now, with reference to the Constitution of India, consider the following: fundamental rights, fundamental duties, DPSPs. Which of the following provisions of the Constitution are fulfilled by National Social Assistance Program? Look, such kind of programs are nothing but the welfareist programs. Their agenda is welfareism. DPSPs are again the product of welfareist system. Fundamental rights are nothing but they promote liberalism, and duties are part of socialist features. So technically speaking, fundamental right is wrong. So this is wrong, this is wrong, this is wrong. Even if you are confused with the fundamental duties, you would be able to identify the correct answer. B is the correct answer. Fine. Moreover, we have not enforced the duties till now. If you talk about the idea of DPSPs, DPSPs are welfareist. They are important for economic and social democracy. They ensure non-concentration of wealth. They have been taken from the communist or the socialist system. Basically, they try to implement the idea of socialism. Whenever the term DPSP comes, the first thing comes into our mind is we have taken it from the Ireland. Ireland has taken it from the Spain. So it was first originated in Spain. From there it went to Ireland, and from there it came to India. So NSEP is also about old age, sickness, then disablement, etc., etc. Now next is salient features of the Constitution. Now I'm trying to cover up all the important PYQs. If a particular area is brought under 5th schedule of the constitution, which one of the following statement best reflects the consequences of it? 5th schedule. What is 5th schedule all about? 5th schedule is nothing but it is about the tribal areas. What are the tribal areas? All the areas which are not the part of 6th schedule are the part of 5th schedule. PESA is also implemented into 5th schedule. Currently 10 states in the country have 5th schedule. Okay, so now what are those 10 countries? This you need to write in the comment section. Now this would prevent the transfer of land to tribals from non-tribals. Yes, this would create a local self-government body in that area already. That was available. This would convert the areas into union territory. No, not at all. The state having such areas would be declared special category state. No, they were to be declared special category from the order of or recommendation of the planning commission, not by any schedule. So this would prevent the transfer of land from tribal to non-tribal, because if you could recall that Nehruji wanted, or the governments at that time wanted, that the land transfer should not happen from tribal to non-tribal, because for the protection of the culture, the tribal land is very important, and if the non-tribals will get into the tribal areas, they would distort the culture of the tribals. There would be assimilation of the culture of the tribals, and they wanted that it should be integrated, and that is why 5th schedule was implemented. Done. Next question, 5th. Yes, the schedule schedule derives the power from certain article only. Here, article 244 talks about 5th and 6th schedule both. 5th and 6th schedule both. Now, which one of the following in Indian polity is an essential feature that indicates its federal character? How will you identify federalism in India? Look, what is federalism? Federalism is nothing but division of power between the center and other units, or division of power between different legislative units of the country. It can be center, state, panchayats, it can be center or state. Now, which of the following is the essential feature which indicates federalism? Independence of judiciary is safeguarded. Union legislature has elected representatives from the constituent units, not a mandatory part of federalism. So we have Rajya Sabha. Union cabinet can have elected representatives from regional parties, not at all. Fundamental rights are enforced by court of law, not at all. Look, independent judiciary is an example of the federal model. We have taken this from US. In US, the Constitutional Court, the Supreme Court of India, the Supreme Court of US, the Supreme Court of US is independent, and this is where you will find that independence of judiciary is federal feature, whereas hierarchy in judiciary is the unitary feature. So judiciary falls in both the cases, unitary and federal. Fine. So what other features are? Two government, division of power, written constitution, supremacy of the constitution. Then you have rigidity, independent judiciary, and bicameralism. Okay, so these are the features of the federal system. Okay. Now consider the following statement. The Constitution of India defines basic structure in terms of federalism, secularism, fundamental rights, and democracy. The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals which Constitution is based. Which of the following statement are correct? Now, Constitution of India defines basic structure. Its basic structure not defined, nor it is the part of the Constitution, nor defined anywhere. It provides for judicial review to safeguard the citizens' liberties, to preserve ideals on which Constitution is based. Yes, judicial review is provided by the Constitution. So you can say that through 13 clause 2, the Supreme Court or the courts try to protect your fundamental rights. Let us see the answer. First is incorrect, second is correct. Next comes question number 17. Under which schedule of the Constitution of India can the transfer of tribal lands to private parties for mining be declared null and void? Which of the following is correct? So obviously we have just discussed this question. Then you can say that Schedule 5 does not allow any kind of land transfers, because over here the land belongs to the tribal areas. And if you could recall that in Samtha judgment as well, the Supreme Court held that the land transfer should not take place. But later on what happened, the state governments gave the power to the governor to decide on the land transfers, and this is where upon the approval of the governor, the state governments have been transferring land to the tribal areas. Now, fifth schedule of the constitution governs administration and control of the certain areas. Samtha judgment, court held that transferring tribal land from mining to private is void under this schedule, and this is where the governor with the advice of TAC can make regulations for peace and good governance in the areas. These includes the restrictions on the land transfers. But now what is happening, because the state governments themselves are interested in transferring the land to the private players for mining purpose, so obviously the TAC recommends this, or TAC suggests yes, it can be done, and then ultimately the governor obviously ensures that, or is involved in the transfers of land. The ninth schedule was introduced in the constitution during the prime ministership of. Ninth schedule is all about the First Amendment Act. First Amendment Act came in 1951. Obviously, at that time, there was the provisional government of the PM Nehru. Nehru was the prime minister at that time. If you could recall what exactly ninth schedule was all about, ninth schedule was put up in the constitution through 31B article. The reason was because the government wanted to do certain reforms in the nation, land reforms, reservation policies, because earlier in Chapangamdurai Rajan case, court held that reservation is invalid. Similarly, in the Patna High Court case, the court held that the land acquisition is invalid, and that is why the parliament came up with this idea, let us create something called ninth schedule, and whatsoever would be put under ninth schedule will not be judicially reviewed. So ninth schedule provided blanket ban to the laws of the parliament as well as laws of the state, and it was passed during the Jawaharlal Nehru's period. Next, right to vote and to be elected is what right? Now, right to vote, when it comes to right to vote, it is a constitutional right given to you under 326 of the Constitution. So obviously, it is not a fundamental right. Nowhere in the Constitution you have got a fundamental right to vote. This you could recall. Then obviously, it is not a natural right. What kind of rights are natural rights? Life, liberty, and property. There are three rights called as natural rights. It can be a legal right as well, but yes, Article 326 of the Constitution provides you the right to vote, and from this only you have got the Representations of People Act 1951. So Article 326 ensures that every citizen above age of 18 has right to vote. Additionally, 62 of RPA 51 states that right to vote is available to everyone who is registered on the electoral roll of any constituency. So obviously, if you have to exercise your right to vote, you need to get yourself registered in your electoral constituency. Out of the following statements, choose one that brings out principle underlying cabinet form of government. Here you need to figure out, these kind of questions are very application based. What you need to do is you need to phase out various, you have to eliminate the various options over here. Only then you would be able to reach the right answer. An arrangement for minimizing criticism against the government whose responsibilities are complex and hard to carry out the satisfaction of all. So it is arrangement for minimizing criticism against the government whose responsibilities are complex and hard to carry out satisfaction of all. Obviously, this doesn't make sense. A mechanism for speeding up activities of the government whose responsibility is increasing day by day. Mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Device for strengthening the hands of the head of the government whose over the people is in state of decline. So obviously, it is all about the collective responsibility. So if you could recall, what exactly is the cabinet system? Cabinet is nothing but cabinet is collectively responsible to the Lok Sabha. So together the cabinet is collectively responsible to the Lok Sabha. This concept of collective responsibility means that Prime Minister along with Council of Ministers are responsible to the House of People. Lok Sabha, House of People. And if PM resigns, the Council of Ministers also have to go and the government falls. And what is individual responsibility? Individual responsibility is towards the president, where if the president deems fit, he can remove any minister because minister is on the pleasure of president. In fact, prime minister is also on the pleasure of president, and there is No tenure given in the constitution for the prime minister post. Prime minister is solely on the pleasure of president. So are the council of ministers on the pleasure of president. Next. So C is the right answer. Which one of the following is not a feature of Indian federalism? Not a feature of Indian federalism. Independent judiciary. The question is not in India. This is a feature. Powers have been clearly divided between central and states. 7th schedule. The federating units have been given unequal representation in Rajya Sabha. It is a result of an agreement among the federating units. No. We are not the federalism of holding together. US is the concept of holding together, where the states came together and did a contract. Okay. So state did a contract and they divided the powers. Whereas India is the concept of, sorry, we are not the concept of coming together. Please rectify this. India is the concept of holding together. Kindly rectify this. Sorry for the error. India is the concept of holding together, where the Ambedkar wanted that Indian federal units should be joined properly so that they shall not run away. And this is also depicted by article number 1, which says that India, which is union of states, we are not United States, we are the union of states, neither the federation of states, it is union of states. Article 3, Parliament has power to add any area to the state, diminish the area, change the name, change the territory, etc., etc. So power lies with the Parliament. So we are not the result of an agreement among the federating units. So obviously A is correct, B is correct. Yes, federating units have been given unequal representation in the Rajya Sabha. Let's see what is the answer over here. So answer is D. A, B, C are correct. Answer becomes D. The main advantage of parliamentary form of government is that. What exactly is the main advantage of the parliamentary form of government? The executive and legislature work independently. It provides continuity of policy and it is more efficient. The executive remains responsible to the legislature and the head of the government cannot be changed without election. Can you change the head of the government without election? Yes. If the head of the government loses the majority, obviously some other person, if the president would call some other person, if he is able to have the majority of 272 plus, so obviously he can become the prime minister. So within by one election only, you can have 2 or 3 prime ministers, provided if one prime minister fails, he loses the trust vote, the government loses the trust vote. If someone else in the house wins the trust vote in that very assembly, in that very assembly, then obviously the person can continue as the PM. So this is wrong. Executive and legislature work independently. This is separation of power. It provides continuity to the of policy and is more efficient. No, not exactly. We always question that. Many times we have seen parliamentary systems are not efficient at all. Why? Because most of the time there is deadlock among the house. Many people are responsible for the lawmaking, not just a single person, and you have to take the consent of all the members sitting in the house. So that becomes a challenge many times. The executive remains responsible to the legislature. Yes, this is the most important advantage, the main advantage of parliamentary form of government. You need to figure out the question is main advantage. So obviously you can prove this as well. To an extent you can prove this as well, but you have to prove the main advantage. So parliamentary system is also known as cabinet responsible. Westminster. Why Westminster? Because it's all started from the British area of Westminster. Provides for collective responsibility. So presence of nominal and real executives, majority party, collective responsibility to legislature, membership of ministers, leadership of PM and dissolution of Lok Sabha. The provision in the 5th and 6th schedule of the constitution are made in order to protect the interest of scheduled tribes. This we have discussed many times. No need to discuss again. You just need to make sure that you know 6th schedule is all about Meghalaya, Assam, Tripura and Mizoram. It does not apply to Nagaland, does not apply to Arunachal Pradesh. Now, which of the following schedules of the Constitution of India contains anti-defection? Anti-defection is in the 10th schedule. It was implemented by 52nd Amendment 1985. 52nd Amendment 1985 introduced the anti-defection law. What is anti-defection law all about? Let us say you are the member of parliament or the legislative assembly from any political party, and in the due course of your assembly you change the political party, you resign from your political party, or you are being removed from your political party. You can be removed, you shall be removed from the house on the grounds of anti-defection. Because you have defected, you have left the membership of your parent party, you have to leave your seat as well. Your seat will fall vacant. Obviously, you have the opportunity to get re-elected, because when your seat would fall vacant, so there would be by-election, the person can recontest on that very seat, either as an independent candidate or the candidate from other party. So this is 10th schedule. Who has the power for disqualification? Speaker has the power of disqualification. Whereas under Article 102, if a member of parliament has to be disqualified, when a member of parliament can be disqualified? If he is holding office of profit, if he has been declared insane, he has been declared bankrupt, or has given away the citizenship of India. In those grounds, you can be disqualified from your member of parliament seat, and this disqualification shall be done by the president, whereas disqualification under 10th schedule shall be done by the speaker. Next comes, in the context of India, which one of the following principles are implied institutionally in parliamentary government? Which of the following principles are implied? Implied means not to be written somewhere, it is already part and parcel. Members of the cabinet are the members of the parliament. Ministers hold the office till they enjoy the confidence in the parliament. Okay, the cabinet is headed by the head of the state. Cabinet is not headed by the head of the state, cabinet is headed by the head of the government. Okay, so this is wrong, so this is wrong, that means this is wrong, this is wrong, this is wrong. Easy. At some places you don't need to apply a lot of mind, you just need to figure out one wrong sentence. It happened in 2013 though, but yes, still you can find such questions. I'll not say all the questions should be done on the elimination technique, but yes, out of 100, if you get 15 questions for elimination, you are able to solve 15 questions because of the elimination technique, you are still in the game. Fine. Next, preamble. So topic number 4 is preamble. Let us see how many questions have been asked. What was the exact constitutional status of India on 26th January 1950? So what were we? We were a sovereign democratic republic. This was taken from the Nehru's resolution or Nehru's objective resolution, that India shall be sovereign democratic republic. This was added later on, so B happens to be the correct answer. This was again a simple question. The preamble of India, so and so. Okay, let me add few things. Resolution, objective resolution. Original objective resolution of Nehru, which was adopted in 1946, consisted of sovereign independent republic. But by the time the constitution was framed and we wrote preamble at the end, preamble was the last paper to be added to the constitution. By the time we were already independent. So what we did, we replaced the word independent from democratic. So we became sovereign democratic republic. Next is the preamble to the Constitution of India is part of the constitution but has no legal effect. Obviously not a part of the constitution, has no legal effect. In the Kesharan Bharati case, court held it is the part of the constitution, and obviously when it is the part of the constitution but it has no legal effect because it cannot be enforced. Part of the constitution but no legal effect, part of the constitution has no legal effect independently of other parts. Okay, So the most appropriate option here would be D. Okay, D would be the most appropriate option. Many times you will find that two or three statements are, or one or two statements, if one statement is directly, if you are able to prove it directly, then obviously there is no confusion. But many times you will find that there are two statements which seems to be similar in nature, then you have to figure out the most appropriate one. Part of the constitution but has no legal effect independently of other parts, obviously independently of other parts. So alone preamble cannot be implemented, but yes, if you go to the Supreme Court asking for your Article 14 and preamble, or you can highlight that the objective of preamble is somewhere mentioned in article number 14, so implementing 14 will implement my preamble as well. That is possible. Now, in the context of polity, which of the following would you accept as the most appropriate definition of liberty? Again, such kind of questions are taken from NCERT. What exactly is the most appropriate? Protection against the tyranny of political rulers, absence of restraint, opportunity to develop whatever one likes, opportunity to develop oneself fully. So here it is more about positive liberty. Negative liberty is all about restraint. When I talk about negative liberty, so that means freedom from restraint. You have freedom from restraint. Whereas the term positive liberty is way ahead. It is not just freedom from restraint, it is also developing oneself. Developing oneself fully. D is the right answer. Which of the following reflects the most appropriate relationship between law and liberty? Okay, this is again a very famous question. What you need to do is, in such questions, you have to figure out by solving it or by trying to eliminate the least important one. If there are more laws, there is less liberty. There is no guarantee. Can you prove this? I cannot prove this. If there are no laws, there is no liberty. Still manageable. If there is liberty, law have to be made by the people. The laws have been made by the parliament, yet we have liberty. So this is also wrong. If laws are changed too often, liberty is in danger. There is no proven fact. Can you prove this? No. Is there any empirical proof? No. Then this happens to be the most appropriate one. If there are no laws, there is no liberty. So this is a guarantee statement. If there is no law in the country, there would not be any liberty in the country. Now next, the question comes, if there is no, next question is, which of the following objectives is not embodied in the preamble to the Constitution of India? Preamble does not contain what? Liberty of thought, liberty of belief, liberty of expression. It doesn't contain the economic liberty. Am I right? So what it contains? It contains thought, expression and belief. Economic liberty or economic justice is more the part of DPSP. Okay. This is done. The mind of the makers of the Constitution is reflected in which of the following? The preamble, of course. It is the identity card to the Constitution. It is the way to read the mind of the makers of the Constitution. So preamble basically gives us an insight what the Constitution makers were thinking while they were drafting the Constitution. So if you see the question, the preamble of the Constitution reflects the vision and values. It talks about justice, liberty, etc. Objectives of the Constitution have been discussed. In fact, Berubari said it is not the part of the Constitution, but later on Keshav Bharti said it is very much part of the Constitution, but it cannot be enforced because it has no backing. What is preamble actually? Preamble is nothing but the summary. So whatsoever has been written in the preamble can be found or can be located in the various parts of the Constitution, specifically the fundamental rights, DPSPs. So that is why preamble is non-enforceable, because you do not have any backing to the preamble. What is enforceable are the independent articles which can be correlated with the preamble. Economic justice as one of the objectives of Indian Constitution has been provided in which of the format? Economic justice as one of the objectives of Indian Constitution has been provided where? Economic justice, the preamble and the fundamental rights, preamble and the directive principle of state policy, fundamental rights and DPSPs, directive rights, DPSPs, none of the above. Economic justice, we have just discussed. Yes, DPSPs, obviously, But again, if you have to figure out, then preamble can somehow be located. So B is the most appropriate answer. How? Obviously, DPSP talks about not directly economic justice, but yes, somehow the preamble also highlights that you have to have socio-economic and political rights. So this is where economic justice can be connected with the preamble. But if directly we need to figure out, then economic democracy is all about DPSP, or DPSP is all about economic democracy. How come economic democracy? Because DPSP talks about non-concentration of wealth. DPSP talks about equal pay for equal wages. DPSP talks about the fair working conditions of the workers, the participation of workers in the factories. So this is where DPSP talks about the economic opportunities of life. So that is why DPSP has more economic tilt as compared to any other part of the constitution. In fact, only DPSP has that economic tilt. Apart from that, the preamble also talks about socio-economic justice of the people, to the people. Now we have citizenship. This is again a very hot topic these days because of the war going on. With reference to India, consider following statements. There is only one citizenship and one domicile. Obviously, we are a unitary system when it comes to citizenship. One citizenship, one domicile. Citizenship by birth can, only citizen by birth can become head of the state. This is wrong. The only eligibility is required is president has to be citizen of India. Now, whether the president can be naturalized citizen, citizen by birth, citizen by registration, so it is up to you. Citizenship by marriage doesn't matter. What matters is that you are the citizen of India on the day when you have applied, when you have submitted your papers for the president election. Okay, number one. In US, the president can only, the president has to be citizen by birth. So that means if you have to if you want to be the president of USA, you have to take birth on the land of USA or the territory of USA. That is not the case in India. A foreigner once granted citizenship cannot be deprived. Yes, can be deprived. Termination of the citizenship has been categorically mentioned under the Citizenship Act of 1955. So this is correct, this is wrong, this is wrong. Which of the following is correct? Only one is correct. A is the correct answer. Fine. So if you can see, Indian citizenship can be terminated where if it has been obtained by fraud, if the person has been showing disloyalty to the Constitution of India, if the person has unlawfully exchanged goods or information at war, and you have been convicted for at least 2 years, 2 years imprisonment. Yes, you have been convicted 2 years in any country within 5 years of the registration or naturalization. Let us say you have got the citizenship through naturalization. What is the naturalization process? Naturalization process is that before the application, you have to spend 14 years in India, and after that, after those 14 years, the previous 12 years have to be in India, and on the day of application, the previous 12 months should be in India. So this we all know, we have already discussed many times at various places. So this is where if the person is not the resident of India, has been out of India for 7 years, if you have flew abroad, you have went abroad and you haven't come back to India for minimum of 7 years, then your citizenship would be terminated because the government of India would feel that you have taken citizenship somewhere else. Next, fundamental rights. Just one question on citizenship. Fundamental rights. Writ of prohibition is an order issued by Supreme Court or High Court. Prohibition is by higher court to the lower court. It's a judicial writ. Okay, so the lower court prohibiting the continuation of proceeding in the case. Okay, so it is a writ issued from higher court to the lower court. Next, under which of the following articles Constitution of India has Supreme Court placed the right to privacy? Right to privacy in Puttaswamy case has been put up under article number 21. 21, right to life means right to privacy. This is simple, straightforward question. The Supreme Court of India has held in some judgments that reservation policy under 16(4) of the Constitution would be limited 335, limited by 335. What does 335 talks about? 335 says that while giving reservation, make sure that you are not compromising the administrative efficiency in the department. So this is the part of the constitution since long, and many times the court has also reiterated the same. We'll discuss. So this statement is correct. Article 335 of the constitution defines the term efficiency of the administration. Make sure that 99.9% of the terms are not defined in the constitution. Constitution doesn't define anything, because defining something would make its meaning parochial. That means it would be limiting that particular idea, it would be exhausting that particular idea. So the constitution makers have just mentioned the word, and definition has changed from time to time, or you can say because constitution is a living law, it evolves from time to time, it has been evolving since time. So that is why this very constitution has been allowed to evolve itself, and the writing down the definitions or defining certain words would have cut off its growth. So that is why you will not find anything defined. Mentioned word is there. Efficiency of administration is mentioned but not defined at all. So this is wrong. So that makes question straight, no confusions. So you can see that polity questions are simple. They can be attempted easily. With the reference, the writ issued by the courts in India, consider the following. Mandamus will not lie against a private organization unless it is entrusted with a public duty. What is mandamus? Mandamus means do your duty. Okay. So where a duty performance, non-performance of duty has been asked. So this is where the idea of mandamus comes in. So command to do your duty. Mandamus will not lie against a company even though it may be a government company. No, it will lie. Any public minded person can be a petitioner. Yes, mandamus can be filed by anyone. Sorry, not mandamus. That is what I am saying. Any public minded person can be petitioner to move the court to obtain quo warranto. We command. Yes, we command. That means by what authority? A person is holding the post. Okay, the question is just about writs. I misread it. I thought it is about mandamus. Please pay attention. Let me repeat. With the reference to the writs issued by the courts, consider the following. Mandamus will not lie against a private organization unless it is entrusted with a public duty. So mandamus is do your duty, and who would be asked to do the duty? The public office would be asked, not a private office. If private office is not performing the duty, the writ cannot be moved. Mandamus will not lie against a company even though it may be a government company. No, it will lie against a company if it is doing the governmental functions. Any public minded person can be a petitioner to move the court to obtain the quo warranto. Means by what authority you are sitting on this post. So obviously when it comes to quo warranto and habeas corpus, these two writs can be filed by anyone, whereas mandamus has to be filed when your right of duty or your right has been breached. If your right has been breached, only you can file the concept of mandamus. So what is 2 is wrong over here. C happens to be the correct answer. Fine. A legislation which confers the execution or administration authority unguided and uncontrolled discretionary power in the matter of application violates the following. This was unnecessary typical question. It says that any legislation which gives power to the executive or administration authority and unguided, uncontrolled discretionary power in the matter of application of law. So that means equality before law. So when you have discretion in the application of law, that means you will not apply the law in the same manner on everyone. There would be inequality in the application of law, and that breach article number 14, equality before law. This is unnecessary, tough question. Unnecessary. Which of the following categories of fundamental rights incorporate protection against untouchability as a form of discrimination? Which of the following fundamental rights incorporates protection against untouchability in form of, if you could recall, right to equality 14, 15, 16, 17. These are all part of right to equality. Then right against exploitation, article number 23, 24, freedom is 19, 20, 21, 22, constitutional remedies is article number 23. Other than the fundamental rights, which of the following parts of the Constitution of India reflects the principles and provisions of UDHR? So UDHR, again, if you could recall, the Universal Declaration of Human Rights. So preamble, directive principles, fundamental duties. If you could recall that in the class we have discussed many times that the UDHR contains one duty. So obviously it can be correlated with the fundamental duty. It talks about the welfare equality. It also talks about the fraternity. So all three are correct. 1 is correct, 2 is correct, 3 is also correct. Which of the which article of the Constitution of India safeguards one's right to marry the person of one's choice? So at that time, when this particular question was asked, right to marriage was a fundamental right. Okay, so that was given as a fundamental right under the Hadia case. Right to marriage equivalent to right to life, article 21. So Hadia case, Shafeen Jahan, the court held that right to choose a partner is essential to person's meaningful existence and autonomy. Hence, it is a fundamental right under article 21. Consider the following statement: the Parliament of India can place a particular law in 9th schedule of the Constitution of India. Yes. The validity of law placed in 9th schedule cannot be examined by any court, and no judgment, no in 𝐼𝑟 it was held that the 9th schedule, laws under 9th schedule can be reviewed if they are against fundamental right, if they infringe your rights. Which of the following are regarded as the main features of rule of law? Now, what is rule of law? Given by A.V. Dicey. Dicey rule of law says that equality before law. Okay. Then you have this court to implement the law. So, limitation of the powers. Obviously, the power would be limited. Equality before law, liberty and civil rights. People's responsibility to the government. People are never responsible to the government. It is the government which is always responsible to the people. Clear? So this corrects. C is the correct answer. Next is right to privacy is protected as intrinsic part of right to life. This we have already discussed. 21. Which of the following are envisaged by the right to exploit, right against exploitation? Prohibition in traffic and human forced beggary, abolition of untouchability. Is it the part? Protection of interests of minorities, protection of employment of children in factories, 1 and 4. C is the correct answer. Fine. So this, Article 23 talks about that that no trafficking in human, no beggary. In fact, 23 clause 2 says that for national interest, if there is a concept of national interest and the government wants to force someone to do any kind of job, obviously the government wants to send you to the armed forces. You cannot say that we have been sent as a forced laborer. So that cannot be done. Okay. So that cannot be done. But while doing so, the government, the parliament shall not, or the government shall not discriminate on the grounds of class, on the grounds of caste, okay, on the grounds of religion, But yes, on the grounds of gender, it can be done. If you could recall that under Article 23, Clause 2, if someone has to be sent for compulsory services, so that compulsory services can be done only for one gender and other gender can be excluded. You cannot say that we have been discriminated. But if the government is doing class discrimination, caste discrimination, race discrimination, religion discrimination, race discrimination, then it is not allowed. I hope you are getting things. We have discussed most of the things in class, if you could recall. In the context of India, which of the following is the correct relationship between rights and duties? Now, in the law, there is a concept of Hoffield theory of rights. Hoffield theory of rights says that every right has a correlative duty. So you cannot do your right unless you do, you cannot claim a right unless you do your duty. Doing duty is an important part of the socialist constitutions. Whereas in India, we have a liberal constitution. US has a liberal constitution. So India and US doesn't talk about the duties, though duties were added into Indian constitution at a very later stage. But earlier in the new constitution, it was never there. US doesn't have duties till now. Only the Soviet constitution had this, Russian constitution has this, Chinese constitution has this. In fact, to an extent, Japanese constitution also talks about duty, but Indian constitution talks about duty, but it doesn't make duty enforceable. So rights are correlative with duties. This is the correct answer. Next, which of the one of the implication of equality in society is the absence of what? Equality means absence of privileges. When there would be privileges, there would not be equality. Either privilege or equality. Only one thing can survive. Which of the following statement is correct? Rights are the claims of states against citizens. Rights are privileges which are incorporated in the constitution of state. Rights are claims of the citizens against the state. Rights are privileges of few citizens against many. So rights are claims of the state against citizens. Does state makes claims against you or you make this claim against citizen? What is right? The other way around is right. Rights are privileges. Rights are never privileges. They are only claims. So this is the right condition. Privileges means absolute rights. Privileges means no restrictions. No restrictions. Whereas rights means restrictions. Now comes DPSP. Under the Indian Constitution, concentration of wealth violates what? The DPSP. Concentration of wealth says that DPSP has been violated. Fine. So Article 38, promotion of welfare of people. Article 39B, non-concentration of wealth. Wealth should be distributed in such sense that everyone, or the ownership should be in such sense that everyone gets the benefit of that wealth. Next, which part of the Constitution of India declares idea of welfare state? This we have discussed many times. DPSP is all about the idea of welfareism. With reference to the provisions contained in Part 4 of the Constitution, which of the following statements are correct? Part 4, they shall be enforceable by courts, they shall not be enforceable by any court. Part 4 is about DPSP. Part 3 is fundamental right. Part 4 is DPSP. They shall be enforceable by court. No, Article 37 says that they are not enforceable. Not be enforceable. Principles laid down part are to influence the making of laws by state. Yes, they are for the influencing the state. So they are directives. Directives means given to the state that these are the directions, follow them. So that is why they are called as directives. In India, separation of judiciary from executive is a DPSP number 50. Simple question. Next is, in India, Legal Service Authority provide free legal aid to which of the following types of citizens? Person with annual income of less than 1 lakh, transgender with annual income of less than 2 lakh, then member of other backward classes with annual income of less than 3 lakh, or all senior citizens? Which of the following is correct? So, if person annual income less than 1 lakh, transgender, correct answer. 1 and 2 has to be correct. This is again a factual question. All senior citizens are not protected actually. So, from this we can figure out 1 and 2, 2 and 3. 3 member of OBC with annual income less than OBC are not protected. Then the answer comes 1 and 2. Women and children, SCs, STs, industrial workers, person with disability. Okay. So, person whose annual income does not exceed 1 lakh, they are protected. Fine. So, senior citizens, it depends on the government rules. So, this was which principle among the following was added to the DPSP by 42nd Amendment to the Constitution? 42nd Amendment. Okay, equal pay for equal work. This was in the original Constitution. Participation of workers in the management of industries. 43A. Right to work, education, public assistance, securing living wages workers. B is the correct answer. B is the correct answer. So what were added by Indira Gandhi? Promote equal justice, free legal aid, take steps for the participation of the workers in the management of industries and environmental safeguards. 48A. Consider the following statements with reference to the Constitution of India. The directive principle of state policy constitute limitations upon what? DPSPs are the limitations upon the legislative functions or upon the executive functions. So what should be the correct answer? Neither one nor two. The DPSPs constitute limitations. It doesn't give limitations. In fact, they are the directives. Fundamental rights are the limitations. So they are the directive. Okay, so they are instructions in fact. So they are instrument of instructions. They are not the limitations. Fundamental rights are the limitations that state shall not. In most of the fundamental right, it is written state shall not. That means state is limited by the definition of that very right. Whereas every DPSP consists of the word state shall, state shall. That means the person or the state is duty bound to perform such things. Consider the following statement regarding the directive principle of states. The principles spell out of the socio-economic democracy in country. The provisions contained in these principles are not enforceable by any court. Both are correct. Okay. Again, this we have discussed. The idea of welfare state is enshrined in DPSP. Again, this is a repeated question, I guess. In the Constitution of India, promotion of international peace, article number 51, DPSP. The state shall ensure promotion of international peace. 51 is clear in dealing with the international peace, maintaining just and honorable relations, fostering international treaties. According to the Constitution of India, which of the following are fundamental for the governance of the country? What are the fundamental for the governance? FR for the people. Duty doesn't matter. FR and FD again. Then governance should be done through DPSPs. DPSP is all about what government should do. And it is also about welfare by the government. So you can say it is nothing but good governance. DPSPs are all about good governance. Welfare and good governance. Next topic is fundamental duties. Which of the following statements are true about fundamental duties? No legislative process to enforce them. They are correlative to legal duties. Again, the point over here is the correlation cannot be established. Okay, so they are not correlative at all. Not correlative means, are they linked with any legal duty or nothing like that has been provided? Okay, so fundamental duties are not legally enforceable, like they are not the legal obligations. In fact, Supreme Court in Ames case 1998 held that they are the moral compass which guides the society. Okay, so they are more like a moral duty of the citizen and less like a legal duty of the citizen. They are not enforceable, but yes, there is a moral duty of the citizen to follow them, and fundamental duties are only for the citizens. Keep this in mind. It applies to citizens only. To uphold and protect the sovereignty, unity and integrity of India is provision made in what? Okay, so protecting sovereignty, integrity and unity of India, again it is the part of the fundamental duties. So next is constitutional amendment. Let us see the kind of questions which have been asked over here. The first question over here is in constitutional amendment. Consider the following statement regarding Nari Shakti Vandan Adhiniyam. So these kinds of questions are again drawn from the current affairs only. The source is current affairs. So consider the following statements with regard to such things. Provision will come into effect from 18th Lok Sabha. Again, not exactly, it was written anywhere. Next is, this will be in force for 15 years after becoming of an act. There are provisions for the reservation of seats for scheduled caste for women within the quota reserved for the scheduled caste. So this 18 Lok Sabha, it is not mentioned anywhere. So this will be in force for 15 years. Yes, we have a sunset clause. What is sunset clause? Sunset clause means that after due date, after the certain mentioned date, the particular act will cease to exist. It will not operate from that very date. So that is called as the sunset clause. Sunset clause. There are provisions for the reservation of seats. Yes. So 2 and 3 seems to be correct. Let us see the answer. Answer is yes, the Constitution 128th Amendment Bill, that is the 106th Amendment, seeks 1/3 reservation for the women in the assemblies and Lok Sabha. Okay. So 2 is correct. Next delimitation exercise is bound to happen somewhere over here. So yes, from 19th Lok Sabha we would see that this particular idea would be implemented. The Constitution 71st Amendment Act 1992 amends the 8th schedule, okay, to the Constitution to include which of the following? So these are again important languages which have been added. So which of the following is correct? Konkani, Manipuri, Nepali, Maithili. So this we just have to make sure we have to know about these things. The last added were the Konkani, Manipuri, Nepali. Maithili was added way earlier. Sindhi was added by 1967. Konkani, Manipuri, Nepali. Bodo, Dongri, Maithili, Santhali was added by at the later stage in 2003. So these are factual things you need to cram on your own. Next is, in India, which of the following constitutional amendment was widely believed to have been enacted to overcome the judicial interpretation of the fundamental rights? Now there was a confusion with regard to such kind of questions. So technically the answer becomes 1. If you will see that fundamental rights basically there was a lot of interpretational issues in the fundamental rights, and that is why in 1951 the parliament had to come up with the First Amendment Act. So let us see what is the answer over here. Answer is A, because the First Amendment Act did away with all kind of ambiguities. Before the First Amendment Act, the problem was whether the fundamental rights can be amended or not amended. In Champakam Dorai Rajan, it was held they cannot be amended. You cannot give DPSPs over fundamental rights. There is no policy of reservation. So ultimately, after that, in First Amendment Act, the Parliament made sure that yes, it can be amended and how they have to be interpreted. Next, consider the following statement. A bill amending the Constitution requires a prior recommendation of the President of India. When a Constitutional Amendment Bill is presented to the President, it is obligation to give the assent. A Constitution Amendment Bill must be passed by both the houses by a special majority, and there is no provision of joint sitting. Which of the following is correct? Okay. So yes, we know there is no option of joint sitting because you have the special majority over here. Clear? Prior permission is not required over here. Why? Because prior permission is required in case of money bill and not such kind of bills. So first is wrong. That makes 2 and 3 as the correct answer. Fine. Answer is B, 2 and 3. Now next question is 65. The 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Do you really think that 44th Amendment would do that? Because 44th Amendment was all about the rectifying things. Then the Supreme Court of India struck down the 19th Amendment of the Constitution as it's being violative of the independence of judiciary. So which of the following is correct? Obviously, it would not be 44 because 44 was the rectification of the things done by the Indira Gandhi government. That was 42. Okay. So that was 42. In fact, it was the 39th Amendment. Okay. It was done by the Indira Gandhi under 39th Amendment, in which she made sure that she added 329A to the Constitution, and through this provision of 329A was added, under which it was written that the election of Prime Minister cannot be challenged in the court. Why? Because Indira Gandhi's election was challenged. 1971 election was challenged. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Okay. No High Court shall have jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Obviously, when it comes to the idea of judicial review, you can see that the judicial review applies to all the laws, and High Court also has power to make the laws of the Parliament void. So neither A nor B, D is the correct answer. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of bill in Lok Sabha only. Amendment can be introduced anywhere. If such an amendment seeks to make changes of federal character, the amendment also requires to be ratified by the all legislature of all the states, more than half of the states. Which of the following is correct? None is correct. D, none is correct. Emergency provisions. Again, as per Article 368 of the Constitution, the Parliament may amend any provision of the Constitution by way of addition, variation, or repeal. Which of the following is correct? Both are correct. Okay. So both, all three are correct. Amendment can be done through addition, it can be done through variation, it can be done through repeal. All are correct. So the Parliament through amendment, Parliament through variation, addition, repeal, change the Constitution or change the articles. Which of the following statements are correct about the Constitution of India? Powers of the municipalities are given in Part 9A of the Constitution. Okay. Emergency provisions are given in Part 18th of the Constitution, and provisions related to the amendment of the Constitution are given in Part 10 of the Constitution. Technically, this was a question which was highly factual. Usually, we do not study it like this. When it comes to the part of the Constitution, we know that there are 22 parts originally, then these parts were increased. So currently we have 25. So again, the question comes over here is, do we have to cram all the parts? Yes, the way UPSC is asking the questions, but okay, we can mug up the parts like this. Part 1 is about union and state, part 2 is about the citizenship, part 3 is about the fundamental right, 4 is about the DPSP, 4A is about the duties, next is about the executives, then we have the Parliament. Okay, so yes, these parts, if you just go through at the last moment, do one thing, just before 3-4 days before the examination, just go through all the parts. Chances are dim that the question would be repeated, but let us not take any risk. And technically, in such scenarios, I'm not saying do this, this is not a suggestion. In such scenarios, technically we have seen all are correct, but no, this is not the thumb rule. Do not say that sir told that it has to be correct, so we marked it correct. Apply your mind over there. if the president of India exercises his power as provided under Article 356, the Assembly of the state is automatically dissolved? No. It cannot be automatically dissolved. Why? Because the court has said you cannot, it will go into suspended animation. SR Bomai case. The powers of the legislature of the state shall be exercisable by or under the authority of the parliament. Article 19 is suspended in the state. No, it is not about 352. No suspension of fundamental rights over here. The president can make laws relating to the state. The power of the legislature of the state shall be exercised or by under the authority of parliament. So out of B and D, which is more appropriate? B happens to be more appropriate. Okay, the laws has to be made by the parliament only. The president will look after the executive functions through the governor. Laws have to be made by the parliament. Which of the following are not necessarily the consequences of the proclamation of president rule in the state? Removal of the council of, again, same kind of question. Dissolution of the state assembly, not a consequence. Removal of the council of ministers in the state, dissolution of the local body, not a consequence. So first is not a consequence, and obviously third is not a consequence. Okay. So 2 is the consequence, obviously. Usually it is nothing but the constitutional breakdown of machinery. This situation will arise in most of the cases when you do not have the council of ministers. It is constitutional breakdown. The chances are that 2 has to be there. So in fact 2 is the consequence. So 1 and 3. Okay. The local bodies remain untouched and assembly is not dissolved. It goes into suspended animation. It is under suspension. Either it will be brought back into life. It is into a coma kind of thing. It will be brought back into life if you find another council of ministers or the situation has been normalized. And if nothing happens, then only the house has to be dissolved after taking all the measures. Next is funds with the government of India. With reference to the union budget, consider the following statements. The union finance minister on the behalf of the prime minister lays the annual financial statement before both the houses of parliament. What prime minister has to do over here? Duty of the president, not the prime minister. At the union level, no demand for grant can be made except on the recommendation of the president of India. Which of the following statements are correct? So first has to be wrong. Union level, no demand for the grants can be made on the recommendation of the president of India. Obviously, president of India recommends a money bill. The money bill is sent to the Lok Sabha and Lok Sabha grants the appropriation. So this is correct. Recommendation of the president is required and then final parliament, the Lok Sabha and the Rajya Sabha has to pass. So 2 happens to be the correct answer. Fine. Okay, the budget, popular name, annual financial statement. President is duty bound to lay down on the floor of the house before the end of the financial year or before the start of the next financial year annual financial statement. Which of the following statements are correct in the respect of money bill in parliament? Article 109 mentions special procedure in respect of money bill. Special procedure, yes. A money bill shall not be introduced in the Council of States, yes. Rajya Sabha can neither approve the bill or suggest changes, can either approve or suggest changes, cannot reject. Amendment to a money bill suggested by the Lok Sabha have to be accepted, suggested by Rajya Sabha have to be accepted by the Lok Sabha. So technically 109 talks about the special provision, it talks about how Lok Sabha has more powers with regard to the money bill. 110 talks about the definition of money bill. Money bill shall not be introduced in the Council of State. Yes, this is what 109 says. It has to be introduced in Lok Sabha only. Rajya Sabha can either approve the bill or suggest changes, but cannot reject. Rejection is not possible because rejection means, again, Lok Sabha is powerful. Rejection will not work over here. C. Okay, it can neither amend nor reject. Changes can be suggested. Amendment is not possible. Suggestions are possible. Now, with reference to the finance bill and money bill in Indian Parliament, when the Lok Sabha transmits the finance bill to Rajya Sabha, it can amend or reject the bill. This was again a question which was asked in 2023. So there was bit confusion in this question. Let us see what was the confusion. It is about, the confusion is whether it is finance bill or a financial bill. Okay. When the Lok Sabha transmits the finance bill to Rajya Sabha, it can amend or reject the bill. Again, that is something not feasible. When the Lok Sabha transmits the money bill to Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations, presuming it is a money bill. Yeah, this is fine. In case of the disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for a financial bill. Again, finance bill actually is the part of budget. So we are presuming this term to be financial bill, as mentioned in Article 117. Now this is where the question, this is where the confusion comes, that which of the following is correct. So technically, if it is financial bill, so these two are correct. Okay, so it is given to affect government for India of the following year. The Rajya Sabha has no power. A finance bill cannot be amended or rejected. Then if there is a disagreement in Lok Sabha on money bill, the matter cannot be referred to joint sitting. So one has to be correct. There is no joint sitting, but a joint sitting is necessary for the finance bill. Clear? Again, it's a normal bill, not a money bill. It must be a financial bill. So this remains the question, challenge that many times UPSC also commits error. Now, system of government. Constitutional government means a representative government of the nation with federal structure, a government whose head enjoys nominal, a government whose head enjoys a real power, a government limited by the term constitution. We have already discussed this question. We will not go into detail now. We adopted the parliamentary democracy based on British model, but how our model differs from that model. As regards legislation, British parliament is supreme or sovereign, but in India, power of the parliament is to legislate is limited. Yes, you have a limited form of system. Next is in India, matter related to the constitutionality of amendment of an act are referred to the constitution bench by Supreme Court. Obviously, a bench of 5 judges can be created whenever there is a confusion over here. So that can be created. So which of the following is correct? Both are correct. Because British follows the parliamentary supremacy. Laws of the parliament are supreme. They cannot be judicially reviewed. They cannot be challenged. In fact, the Supreme Court of UK started only in 2009. Once they approved the amendments or the reforms to the laws in 2005. So they started with the Supreme Court 2009. Till now as well, Parliament power is supreme. No judicial review on the Parliament's power. So technically this becomes the idea of parliamentary supremacy. Whereas in India, the laws of the Parliament can be judicially reviewed and judiciary will send it to a constitutional bench, usually consisting of not less than 5 judges. So Indian model, republican system, they have a monarchical system. Again, I'll provide you the slides. You can just go through the slides, I guess. Now, parliamentary system of government is the one in which all political parties in the parliament are represented in the government. Okay, no. Or the government is responsible to the parliament and can be removed by it. Parliamentary system. The government is elected by the people and can be removed by them. No, we cannot remove them. The government is chosen by the parliament but cannot be removed before the fixed term. So what is correct? B is correct. Responsible to the parliament. Parliament once passes no trust vote, no confidence motion, and if the opposition wins the no confidence motion, the government is defeated. The government has to go. Constitutional government is a definition, by definition is a limited government. This is again a kind of a repeated question. Democracy's superior virtues lies in the fact it calls into activity the intelligence and character of ordinary men and women. It is not about the intelligence and character. Character and intelligence doesn't matter. The method for the strengthening executive, weakening a superior individual with dynamism are, just a moment. The intelligence and character of ordinary men and women, yes, ordinary men. The term is ordinary men. The method for strengthening the executive leadership, it is for the weakening superior individual with dynamism and vision. So it doesn't create any kind of hierarchy differences. There is no superior, no inferior. So this is a band of dedicated party workers. This is wrong. So as you can see, at a very first instance, I presumed A to be wrong, but no, A is right. So what you need to do is, in such scenarios, you have to weigh all the options. You have to see which is the most closest one. Obviously, dedicated party workers is all about communism. It is not democracy. It is a communist system. Superiority, democracy is all about equality. Everyone has a voting right. Intelligence and character of ordinary men and women. Okay, so this happens to be the most closest answer. In fact, it is Schumpeter's definition. Joseph Schumpeter's work on democracy highlights the real strength lies in the engaged ordinary citizens in the political life. There is parliamentary system of government in India because Lok Sabha is elected directly by the people, Parliament can amend the constitution, Rajya Sabha cannot be dissolved, Council of Ministers is responsible to the Lok Sabha. So again the question comes that the most closest answer over here happens to be the D, parliamentary system, because Council of Ministers are responsible to the Lok Sabha. That gives the nearest answer. India's parliamentary system because here the Council of Ministers are directly responsible to the Lok Sabha. Consider the following statements. A constitutional government is one which places effective restriction on individual liberty in the interest of state authority, places effective restrictions on authority of the state in the interest of individual. So restrictions on individual or restrictions on authority, what is much closer or much better? B happens to be the, because constitutional government puts restriction upon the authority and not on the individuals. Next question is with regard to president. Consider the following statements. The members nominated to either house of the parliament or the legislative assemblies of the state are also eligible to be included in electoral college. Members nominated. Electoral college consists of the members elected from the Lok Sabha, elected members of the Rajya Sabha, as well as elected members from the Legislative Assembly. Currently, we do not have nominated members in Lok Sabha and Legislative Assembly. That has been removed in 2019 through 104th Amendment. Now, currently, we only have the nominated concept in Rajya Sabha, but yes, they do not participate in the election of president. Okay. The higher the number of elective assembly seats, the higher is the value of vote of each MLA of the state. The value of the vote of MLA of Madhya Pradesh must be greater than that of Kerala. The value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh because of the ratio of population. Okay. So because of the ratio of population to the total number of selected seats in Puducherry is greater than compared to Arunachal. Now again, if you will see, this is wrong. Statement 2, higher the number of elective assembly, higher is the value of the vote of each MLA of state. Again, higher the number of the assembly. Okay, the higher the number of assembly, the higher value of vote of each MLA of the state is not always true because it always depends upon the total population. So if you could recall the formula over here, then you would be able to solve the question. Quickly, if you could recall for this particular question, you need to have the formula of the president election. Fine. Then obviously 3 is also incorrect and 4th is correct. Value of the vote of each MLA of Madhya Pradesh is greater than that of Kerala, because now population is important over here. So obviously Madhya Pradesh has more population, Kerala has less population. I'll just go through one page over here. These kinds of questions can be resolved usually value. So again, you have to go through this list. This I always show in the class as well, if you could see. Andhra Pradesh, value of each MLA. Arunachal Pradesh, population. Okay, the question is that the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. Madhya Pradesh, Kerala is 152, and obviously when it comes to the Madhya Pradesh, it is 131. Again, this was a question which we need to mug up, but yes, we have the formula in hand. So what exactly is the formula of the total value of the MLAs? It should be the total population of the state divided by the number of elected members into 1/1000. So this is the formula, but again, we have to be aware about the numbers over here, the values over here. 1971 is the census, so we need to cram those things. So usually such question comes. Again, in such questions, we have to apply our intelligence. The value of the vote of each MLA Puducherry is higher than that of Arunachal. This is correct because the population is higher over there. So that makes only one statement is correct. Only 4 is correct. Rest are wrong. Consider the following statements. So if you could see, recently they have been asking a lot many questions on the election of president. Why? Because in 2022 the election of president happened. So this time there might be a question on the election of Rajya Sabha. The election of the President of India is declared void by the Supreme Court. All the acts done by him in the performance of duties before the date of decisions become invalid. No, Constitution says they do not become invalid. Elections for the post of President of India can be postponed on the grounds that some legislative assemblies have been dissolved and elections are yet to take place. No, Jammu and Kashmir was not there. As in Jammu and Kashmir, MLAs were not elected there. There is a vacancy in the electoral college. The term is that even if there is a vacancy in the electoral college, the elections are bound to happen. Next comes, when a bill is presented to the President of India, the Constitution prescribes the limit. No, this is what is called as constitutional punctuality, and this is what being asked from governor now. In the recent case, the court said that the governor should be bound by the idea of constitutional punctuality. That means he should be punctual. Okay, so none is the correct. He should not misuse the idea of pocket veto. All are incorrect. With reference to the election of the President of India, consider the following statements. The value of the vote of each MLA varies from state to state. Fine. Value of the vote of each MLA will vary from state to state. Why? Because here population is involved and every state has different populations. So obviously value would differ. The value of the vote of MPs of Lok Sabha is more than the value of the MPs of Rajya Sabha. No, for Lok Sabha, Rajya Sabha, we have the same formula. So it should not be correct. So is the correct answer. 1 is correct. Statement 2, value of vote of each MP is same in case of Lok Sabha, because this is where you have to ensure the uniformity. Each Lok Sabha, Rajya Sabha MP should represent almost equal amount of population. Okay, so this is where the total values of all MLAs divided by total number of elected MPs. Fine. So we have just discussed this here as well, if you will see. For when it comes to the value of vote of each MLA, each MP of Rajya Sabha, Lok Sabha is 708. Okay. Next comes this we missed a question. Yes. Consider the following statements. The executive power of union invested in the Prime Minister. The Prime Minister is the ex officio chairman of Civil Services Board. Now, when it comes to the executive power of union, who is responsible? Is vested in what? What about article number 53? What does article 53 says? 53 says that president, it is vested in the president. The Prime Minister is the ex officio chairman. Is he? No. Cabinet Secretary is the ex officio chairman. 53, Cabinet Secretary. Again, these kinds of questions are highly factual. The President shall make rules for the more convenient transaction of the business of the Government of India and for the allocation among the ministers of the said business. All executive actions of the government shall be expressed and taken in the name of President. Which of the following is correct? 1 happens to be correct, only A is correct, 2 is wrong. Fine. Next comes Vice President. Consider the following statements. The chairman and the deputy chairman of Rajya Sabha are not the members of the House. Chairman is not the member, he is the ex officio, deputy chairman is the member. While the nominated members of 2 Houses of Parliament have no voting right in the presidential election, they have right to vote in the elections of Vice President. When you see that the Vice President election, so in that case, it is by electoral college, only the Lok Sabha, Rajya Sabha participate. So obviously, both the members participate. Done. Next comes the Prime Minister of India at the time of his or her appointment. Need not necessarily be the member of one of the House of the Parliament, but must become the member of either house within 6 months. Need not necessarily be the member of one house, must become Lok Sabha. No. In India, there is no rule that PM has to be the member of Lok Sabha. PM can be the member of any house. Whereas in UK, the rule has been set after 1945 through Salisbury Convention. Salisbury Convention says that only the PM can only come from the lower house. That is House of Commons. Not in case of India. Must be, Dr. Manmohan Singh was member from Rajya Sabha. Must be member of one of the House of the Parliament. Must be a member, not necessary. Must be member of Lok Sabha, not necessary. So upon being appointed as the Prime Minister, a person has 6 months to be the member of any house. If he fails to be the member of any house, then technically he has to resign. Next question is, topic is Parliament. Next comes the topic of Parliament. With reference to the Parliament of India, consider the following statements. Prorogation of House by President of India does not require the advice of the Council of Ministers. Prorogation of House is generally done after House is adjourned, sign time. Obviously, anything in the Parliament has to be done. The President is bound by the advice of the Council of Ministers. The President doesn't have constitutional discretion. So whatsoever he is doing, he has to do through the Council of Ministers. Prorogation of House is generally done after the House is adjourned, signed in, but there is no bar of the President to prorogate the House which is in session. Yes, Article 85 says that. 85 says that the President can summon, prorogate or dissolve the House, the Lok Sabha. Summon the House, prorogate the House and dissolve the Lok Sabha. Dissolution of Lok Sabha is done by the President of India who say in the exceptional circumstances. What are these exceptional circumstances? When the Council of Ministers are not there. When there is no Council of Ministers, then the President can dissolve on his own. When there is on her own. When there is Council of Ministers, the President has to ask this from the Council. So that makes 2 and 3 should be correct. C happens to be the correct answer. Now the question is, with reference to the Indian Parliament, a bill pending in the Lok Sabha lapses on its dissolution. Anything which is pending in Lok Sabha, anything which has been introduced by Lok Sabha, pending in Rajya Sabha, shall lapse on the dissolution of Lok Sabha. Next is a bill passed by Lok Sabha pending in Rajya Sabha shall lapse on the dissolution of Lok Sabha. This we have just discussed. Yes. Bill in regard to which President of India notifies his or her intention and summon the joint sitting lapses, does not lapses. What kind of bill does not lapses? There are three kinds of bills which do not lapses. What are those? Any bill which has been introduced in Rajya Sabha, pending in Rajya Sabha, shall not lapse on the dissolution of Lok Sabha. Any bill which has been, in which the president has called joint sitting, shall not lapse. Any bill which is pending with the Committee on Assurances shall not lapse. Okay, shall not lapse. So now let us see the answer. So first is correct, 2 is correct, third is wrong. Answer is B. First is correct, 2 is correct, and C is wrong. Okay, bill pending in Rajya Sabha but not passed by Lok Sabha does not lapse. Bill pending passed by both the houses, assent of does not lapse. The bill does not lapse. Okay. So again, there are other conditions does not lapse. Now, with reference to the Speaker of Lok Sabha, consider the following. While any resolution of the removal of Speaker of Lok Sabha is under consideration, he shall not preside. Now again, if you do not know the answer, you can easily identify such answers through the principle of natural justice. No one shall be judge in his own case. That means if his removal procedure is going on, he cannot sit on the chair. Rather, he would sit as a member. He shall not have right to speak. Yes, he shall have. He shall not be entitled to the vote on first instance. Yes, he can have. When he is on the chair, when the speaker is on the chair, he will not have vote on first instance because he will always have a tiebreaker vote, a casting vote, tiebreaker or a casting vote. But when he has been sitting as a member, his removal procedure is going on. In that scenario, he can sit in the house and vote. Which of the following is correct? First happens to be correct. He cannot preside, though he may be present, he can speak, take part in the proceedings and can vote in first instance. Okay, and obviously not in the equality of votes. So when tie happens, then he cannot, he should not. Which of the following statements about ethics committee is correct? This committee was in news last year, that is why there was a question. Initially, it was an ad hoc committee. Only member of Lok Sabha can make a complaint relating to the unethical conduct of the member of Lok Sabha. The committee cannot take up any matter which is sub judice. So initially, it was an ad hoc committee. Yes. Only a member of Lok Sabha. No, you can also file the complaint to the speaker if you feel like that something wrong has happened. So then you can file it. Next, a person can file the member through another Lok Sabha MP. Okay, so obviously what you need to do is you have to search or you have to go to an MP and you need to file it. Then again, the committee does not entertain the complaints based on the media reports. Okay, it cannot take up anything which is sub judice. When the matter is pending with the court, then the committee cannot interfere. Committee has to wait and watch. So C happens to be the correct answer. With reference to India, consider the following. Unauthorized of the official police or military uniforms, knowingly misleading or otherwise interfering with a police officer or military engaged in their duties, celebratory gunfire which can endanger to the safety of others. Which of the following are correctly matched? Okay, yes, this must be correctly matched. Which of the following are correctly matched? Unauthorized of official or military uniform, the Official Secret Act, knowingly misleading, otherwise interfering with a police officer or military engaged in their duties should not be correct. So the answer is yes, it is the part of the Official Secret Act again, and 3 is also correct. Again, these are the factual questions. With reference to the Deputy Speaker of Lok Sabha, consider the following statement. Currently, this post is vacant. This is a constitutional post. As per the rules of the procedure and the conduct of business, election of Speaker shall be held on the date as a Deputy Speaker as the Speaker may fix. There is mandatory provision that election of a candidate as Deputy Speaker of shall be from either principal opposition or ruling party. No, it is not a mandatory provision. It is mere convention. Clear? Next, the deputy speaker has the same power as of speaker when the presiding over the sitting, and no appeal lies against his rulings. Fine. The well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker, duly seconded by the prime minister. No. First is wrong. The election of deputy speaker shall be held on such date as speaker may fix. Sorry. Which of the following are correct? We have to figure out. This is correct. There is a mandatory provision that election of candidate of speaker shall be from either principal. No, this is wrong. The deputy speaker has the same powers. This is correct. The well-established parliamentary practice regarding the appointment of deputy speaker is that motion is moved by speaker, seconded by parliament. No. It is nothing like this. The constitution only says that there shall be speaker and deputy speaker to be elected by the house. So 1 and 3 happens to be the correct answer. Okay. Next, which of the following are the exclusive powers of Lok Sabha? To ratify declaration of emergency. Ratification of emergency is the exclusive power of Lok Sabha. Yes or no? It is the power of both. Motion of no confidence against the Council of Ministers. Yes. Impeach the President of India. Both. So B happens to be the correct answer. Impeachment, both. Rajya Sabha, Lok Sabha equal powers. Emergency, both have equal powers. Yes. For revocation, removal of emergency, then Lok Sabha has power. Okay. Consider the following statements. The Constitution of India classifies the minister into 4 ranks. Cabinet minister, minister of state with independent charge. Constitution does not classify them. Constitution only says that there are council of ministers. The total number of ministers in the union government, including the prime minister, shall not exceed 15% of the numbers in Lok Sabha. Fine. Which of the following is correct? Okay. So 91st Amendment 2001 applied 15% cap. Okay, 15% cap. When it comes to the Legislative Assembly, it is 15%, not more than 15% and not less than 12. In case of Delhi, it is 10%. Okay, so Delhi has 10% rule. Assemblies have 15%, Lok Sabha has 15%, but in Assembly, the Council of Ministers should be more than 12 and less than 15%. In Lok Sabha, it is only more than, not more than 15%. Consider the following statement. In India, there is no law restricting the candidates from contesting in Lok Sabha from 3 constituencies, 3 or 2. In 1991, Lok Sabha elections, Sridevi Lal contested from 3 Lok Sabha constituencies. Okay. As per the existing rules, if a candidate contests in 1 Lok Sabha from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him in the event of her winning the constituencies. Which of the following is correct? Only 2 is correct, because after that the rule was changed. As per 33(7), one candidate could contest to only 2 constituencies. If they win from 1, then by-polls happens. Okay. 2 is 1991 Haryana Deputy Chief Minister contested from 3 Lok Sabha seats. Fine. Then 3 is incorrect. There is no such provision. If the candidate is contesting from 1 constituency, he has to lodge separate return of election expenses for every election. Okay. The ECI bears the cost. Okay. So again, the question was later on cancelled with regard to the confusion. So we are also cancelling it over here. Next, with reference to the funds under the Member of Parliament Local Area Development Scheme, it's a scheme. MPLAD funds must be used to create durable assets like physical infrastructure for health, education, etc. A specified portion of each fund must benefit SC/ST population. Okay. Then MPLAD funds are sanctioned on yearly basis and unused fund cannot be carried forward. No, they can be carried forward. So they get accumulated for complete 5 years. District authority must inspect at least 10% of work under implementation every year. Fine. 1, 2 and 4 happens to be the correct answer. First is correct. Okay. So again, this is a factual question. Why it was asked? Because during COVID, MP-led fund was suspended. So any constitutional provision, any scheme, any welfareist policy gets suspended, implemented. So there are chances that question would be asked. According to the Constitution of India, person who is eligible to vote can be made a minister in the state for 6 months, even if or she is not the member of the legislature of that state. Now this is something which is invalid. Okay, so if you have not the who is eligible, according to Constitution of India, person who is eligible to vote can be made a minister of a state for 6 months, even if he is not a member of the legislature of that state. Okay, correct. According to the Representation of People's Act, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting election even after his release from the prison. Okay. Now again, both seems to be wrong. Not merely you are eligible to vote. Okay, the Constitution of India, not merely eligible to vote, can be made a minister for 6 months, even if you are not the member of Legislative Assembly of the state. Again, when it comes to state, then obviously the UPSC gave D over here. So next is the disqualification is only for the 6 years. It is not for the lifetime. It is not permanent in nature. So both happens to be wrong over here. Next, consider the following statements. The President of India can summon a session of Parliament at such places as he or she thinks fit. Can it happen? The Supreme Court seat can be shifted anywhere else. Similarly, the power to meet the session, the power to bring the session is with the President. The Constitution of India provides 3 sessions of the Parliament, but it is not mandatory to conduct. It doesn't provide, it only says between 2 sessions, there should be a maximum gap of 6 months. There is no minimum days that Parliament is required to meet in the year. Fine. So that makes C the correct answer. So C is the correct answer. Rajya Sabha has equal powers with Lok Sabha. In the matter of All India services, this is exceptional power of Rajya Sabha. Amending the constitution, both have the same powers. Removal of the government, only Lok Sabha has power. Making the cut motion, only Lok Sabha. Why? Because Lok Sabha has powers in the annual financial statement, in the budget. So 2 happens to be the correct answer, B. Next, 102. Along with the budget, the finance minister also places other documents before the parliament, which includes the macroeconomic framework statement. The aforesaid document is presented because it is mandated by. So now when it comes to the macroeconomic framework statement, is not the part of the constitution, nowhere written in the constitution. It is from the provision of fiscal responsibility budgetary management act of 2003. So this is more like an economics question which has been asked over here. Next comes, consider the following statements. The Parliament Prevention of Disqualification Act 1959, it exempts several posts from disqualification on the grounds of office of profit. Okay, the Parliament Prevention of Disqualification Act of 1959, yes, it exempts. The above mentioned act was amended 5 times. The term office of profit is well defined in the constitution. I have already discussed many times that nothing is well defined in the constitution. Yes, this act has been amended many times. Okay, 5 times it has been amended. So yes, it has been amended. So that makes A as the correct answer. 1 and 2 as the correct answer. Next, in India, which of the following review the independent regulators like in sectors like telecommunication, insurance, electricity? Ad hoc committee set up by the Parliament, Parliamentary Department related standing committees, Finance Commission, Financial Sector Legislative Reforms Commission, Niti Aayog. Which of the following is correct? So ad hoc committees set by the Parliament, Parliamentary Department related standing committees, they take care of them. Finance Commission doesn't. Financial sector, let us say Finance Commission. We know that Finance Commission is not responsible for regulating anything in the country. No regulation at all. So that makes these options can be phased out. Next is what option we have in hand. We know first is valid. 2 is valid, so that automatically makes 1 and 2 as the correct answer. So let us see the answer. A is correct. So these are managed by the standing committees in the parliament. Consider the following statement. In the first Lok Sabha, the single largest party in the opposition was Swatantra Party. So these are kinds of questions which have been asked from the NCRT. So no, it was not the Swatantra Party. Swatantra Party, in fact, could not win elections, or in fact, it was found at very late stage. Next, the second largest was CPI. Everyone knows the fact. Second largest was CPI, and CPI was the only threat to the Congress. In the Lok Sabha, leader of opposition was recognized for the first time in 1969. Yes, first time it was recognized, because the Mavlankar rule was applied for giving the post of leader of opposition, and G.V. Mavlankar, the first Speaker of the Parliament, said, Lok Sabha said that if you do not have 10% MPs with you, you cannot claim this post. First time Indira Gandhi gave this. This is right. This is wrong in the Lok Sabha. If the party does not have minimum 75 members, its leader cannot be recognized as leader of opposition. No rule as such, but yes, applies to 55. So answer comes 1 is incorrect, 2 is correct, 3 is incorrect. It should be 10%. Fine. So now you would be able to mark the correct answer. With reference to the Parliament of India, which of the following parliamentary committees scrutinizes and report to the House whether the power to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the executives? So, as you can see, that Committee on Government Assurances, what is the task of Committee on Government Assurances? It just check that what kind of assurances have been made in the bill. Do the government have money? Does the government have money to implement such assurances? Committee on Subordinate Legislation, Rules Committee, obviously. Then you have Business Advisory Committee. B happens to be the correct answer. So Committee on Subordinate Legislation, it scrutinizes everything. Then Rules Committee set up the rules of the House, and then Business Advisory Committee focuses on the time allocation, how the bills should be implemented, what should be the sessions and everything. Regarding money bill, which of the following is not correct? So always keep in mind the question not correct. So what do you understand? Not correct. A bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. A money bill has provisions for the custody of the Consolidation Fund of India or the Contingency Fund of India. A money bill is concerned with the appropriation of money out of the Contingency Fund of India. No, it is not out of the Contingency Fund of India. It is always from the Consolidated Fund of India. So this happens to be the not correct statement. Money bill deals with the regulation of borrowings or giving any guarantee by the Government of India. It is written in Article 110. 110. Okay, custody. Okay, and then this. The correct answer is C. So it talks about abolition, imposition, remission, alteration, regulation, borrowing of money, custody of Consolidated Fund of India or Contingency Fund of India, payment from the monies out of this fund, appropriation of money out of the Consolidated Fund of India, declaration of any expenditure, receipt of money on the account of Consolidated Fund of India, or any incidental matter. Done. 108. For election to the Lok Sabha, nomination paper can be filed by anyone residing in India, a resident of the constituency from which the election is to be contested, okay, any citizen of India whose name appears in the electoral roll, or just any citizen of India. Obviously, C happens to be the most nearest and the most appropriate answer. Not nearest, most appropriate. So if you want to contest the election, what you need to do is, for the lower house, you need to have the certain eligibility. What are the eligibility? You have to be a citizen of India. You have to be a minimum of 25 years of age, or any other eligibility as proposed by Parliament. So that can also be added. So there is a scope in the Constitution under Article number 82, 83. For a candidate to stand for election, Lok Sabha. Okay, yes, this we have discussed. Consider the following statements. In the election for Lok Sabha or State Assembly, winning candidate must get at least 50%. No. We have first past the post system. That's it. No. Then according to the provisions laid down in the constitution, Lok Sabha, the speaker post goes to the majority party deputy speaker. It is not written anywhere in the constitution. It is mere convention. So it is mere convention that the speaker post goes to the ruling party and the deputy speaker post goes to the opposition party. D is the correct answer. The Parliament of India exercises control over the functions of Council of Ministers through. How the Parliament keeps a checks upon the government. Check can be done through adjournment motion, can be done through question hour. These are all devices of the Parliament to keep a check. It can be done through the supplementary questions, starred questions, unstarred questions. So yes, all of them are correct. Fine. So adjournment motion, it is used to draw the attention of the House for a definite matter. If matter is urgent, matter is very much necessary. Public importance. Question hour, it is a way through which the opposition asks the questions. It is a tool of asking questions from the government. Obviously, question hour also keeps a check upon the government. Next happens to be the supplementary questions. Supplementary questions are basically questions in which the replies can be sought or the replies can be immediately sought for the original question. Finally, so we have three types of questions. Starred questions. Starred questions are like this. They only require oral answer. Something in which you require oral answer, that means a supplementary question can be asked. Okay. Then unstarred questions, you require a written answer. If I put my question as unstarred, I'll be seeking a written answer. So in that case, I cannot ask a supplementary question. And then you have the short notice questions, usually introduced within the 10-day limit. Okay, if you need to ask something, so at least should be given before 10 days so that oral answers can be sought over here. Okay, short notice within the 10 days, your question would be discussed. With reference to the Parliament of India, consider the following statements. What are the following statements? A private member bill is a bill presented by a member of Parliament who is not elected but only nominated by the President of India. No, private member bill is a bill which can be introduced by anyone who is not a minister. He can be a BJP MP, he can be a Congress MP, he can be a BSP, SP MP. Anyone who is not a minister, his bill is called as the private member bill. There are two kinds of bill, the public member bill and the private member bill. Public member bill are introduced by the ministers and the private member bill can be introduced by anyone. Private member bill can also introduce money bill. There is a confusion in the market. Everyone tells no, it is not. Yes, it is the case. The private member bill can be a money bill as well. No bar upon this particular fact, because in a parliamentary democracy, everyone is equally responsible. Every member of parliament is equally responsible for law making. In the parliament, the government doesn't have extra powers. In the parliament, the prime minister being the leader of the house, the Rahul Gandhi being the leader of opposition, technically have same powers. Okay. Obviously, one is the government, other is the opposition. But yes, for parliamentary functions, they will have same powers. So recently, a private member bill has been passed in the parliament for first time in its history. No, 14 members bill have been passed. We have discussed everything in the class. 14 bills have been passed till date. Okay, so both are incorrect. Both are incorrect. Next. The Parliament of India acquires the power to legislate on any item in the state list in national interest if resolution to that effect is passed by. Parliament of India acquires power to legislate any item. That means in the national interest, that particular resolution is passed by. In what? This is a special power given to Rajya Sabha. Rajya Sabha by majority of not less than 2/3 member present and voting. Okay. So as per Article 249, the Rajya Sabha can legislate on any matter which is of public importance on the state list. So this is where we are also a unitary. We also have a unitary feature that Rajya Sabha can do such things. Consider the following statements. Rajya Sabha has no power either to reject or to amend a money bill. Yes, neither they can reject nor they can amend. Rajya Sabha cannot vote on the demand for the grants. Obviously, demand of the grants, Rajya Sabha doesn't have powers. Rajya Sabha cannot discuss annual financial statement. Yes, they can always discuss annual financial statement. So which of the following are correct? 1 and 2 happens to be the correct answer. Fine. 3 is wrong. They can discuss. When a bill is referred to a joint sitting of both the houses, it has to be passed by simple majority, members present and voting. No, there is no 3/4 majority. There is 2/3 majority not required, absolute majority not required. What bills will go to? When the bills will go to? When there is a deadlock. Who will propose? The president. Who will preside? Speaker, deputy speaker, deputy chairman. What shall be the voting pattern? The voting pattern shall be simple majority present and voting. Consider the following statements regarding a no confidence motion in India. There is no mention of no confidence motion in the constitution. Yes, it is a parliamentary device. A motion of no confidence can be introduced only in Lok Sabha. Why? Because the government sits in Lok Sabha, the government falls in Lok Sabha, hence it can only be introduced in Lok Sabha. Okay, yes, there is no mention. This is correct. This is correct. So C happens to be the right answer. Which one of the following is the largest committee of the parliament? Largest committee, oldest committee. So these are usual terms which may be asked. So obviously, the committee on estimates, the committee on public accounts, public undertakings and petitions. Estimates happens to be the largest one. Why? Because it consists of the 30 members. Okay. So it was first created on the recommendation of John Mathai, consists of 30 members, all from Lok Sabha, happens to be the largest one. Ministers cannot be the member of such committees. So basically its function is to examine the budgets and also suggest the economic policies. As you know, whenever the annual financial statement is laid before the house is given a recess, a break, and then the grants are sent to the estimate committees. The estimate committee scrutinizes the grants and then they just come up with the recommendations that whether the grants are in right direction or wrong direction, whether there are less grants or more grants. Okay. Okay, let us quickly revise this. This is something which students are always confused. Committee on public accounts is primarily, it is a post-mortem kind of committee. Idea is just to check whether the money has been spent in a wise manner or not. 22 members, 15 Lok Sabha and 7 are from the Rajya Sabha. Then public undertakings, again this committee is to ensure that whether the PSUs are working in the right direction. It is just to scrutinize the working of the PSUs. There are 22 members, 15 and 7. Then committee on petitions, it examines the petitions referred to it. Again, it consists of 15 members. Members are elected from both the houses. Committees are, the members of the committees are elected annually. Election happens on annual basis. You have a term of 1 year. For 1 year, you would be the member of committee. Which one of the following are the functions of the cabinet secretariat? Preparation of agenda of the cabinet meetings, secretariat assistance to the cabinet committees, allocation of financial resources to the ministers. Okay. Financial resources to ministers cannot be allocated by the cabinet secretariat. Secretariat is mere executive. It has executive functions. So 1 and 2 has to be correct. Okay. Ministry is entrusted. Consider the following statements. The Parliamentary Committee on Public Accounts consists of not more than, we have just discussed this question. PAC examines the report of CAG. Yes. Scrutinizes appropriation and financial accounts of the government. Yes or no? Yes. Consists of not more than 25 members of Lok Sabha. Okay. This is wrong. 15 plus 7. Consider the following statements. Council of Ministers in Centre shall be collectively responsible to the Lok Sabha or Parliament. The Union Minister shall hold office during the pleasure of President of India. Prime Minister shall communicate to the President about the proposals for legislation. Yes, article number 78. 77 and 78. Okay. So, one happens to be incorrect. Responsible to the House of People only. What will follow if money bill is substantially amended by Rajya Sabha? The Lok Sabha may still proceed with the bill, accepting or not accepting. The Lok Sabha cannot consider the bill further. The President may call a joint sitting. The Lok Sabha may send the bill to Rajya Sabha for reconsideration. Okay. Substantially amended. Recommended. Again, the question, language of the question is wrong. This is the correct answer. Substantially amended. Okay. As you know, Rajya Sabha cannot amend. Even if the Rajya Sabha gives recommendations, the Lok Sabha is not bound by the recommendations. If Lok Sabha accepts the recommendation, the bill shall be deemed to be passed by both the houses, and if not, the bill is deemed to be passed by the Lok Sabha and Rajya Sabha without recommendations. The Parliament can make any law for whole or any part of the country implementing international treaties with the consent of states, with the consent of the majority of states, with the consent of states concerned, no, without any state concern. Why? Because article number 51, it gives the duty to the Parliament. Okay. Plus at the same time, you have article number 253. For international matters, you can make the laws on the concurrent list as well. Now next is, in Parliament of India, the purpose of adjournment motion is to allow discussion on a definite urgent public importance. We have just discussed this question, I guess. A is the correct answer. We have just discussed this. Consider the following statements. Union territories are not represented in Rajya Sabha. Yes, Chandigarh has been asking the representation, but it's tough. Is it within the purview of Chief Election Commissioner to adjudicate the election disputes? According to Constitution of India, the Parliament consists of Lok Sabha and Rajya Sabha only. Parliament consists of Lok Sabha, Rajya Sabha and the President of India. So this is wrong statement. This makes these two statements wrong. So Chief Election Commissioner to adjudicate the election disputes. No, who will adjudicate? The High Court will adjudicate. So Union territories are not represented in Rajya Sabha. First A is the correct answer. Are not represented in Rajya Sabha. Okay. Now the question is incomplete. Union territories having legislature. Now the question over here would be, answer would be none. What is marked over here? Incorrect. Wherever they exist, obviously. So the answer is incomplete. So in that manner, D has to be the correct answer. Okay, D has to be the correct answer. Higher judiciary and Supreme Court and High Courts. Pursuant to the report of Sanyal Committee, the Contempt of Court Act 1971 was passed. 2022 question. The Constitution of India empowers the Supreme Court and High Court to punish for the contempt of themselves. Okay. Obviously, first is correct. The Constitution of India defines civil contempt and criminal contempt. Constitution of India does not define anything. In India, the Parliament is vested with powers to make laws on contempt of court. So this particular subject is not categorically mentioned. But yes, the Parliament has made a law, Contempt of Courts Act 1971. So first is correct, 2 is correct, and Supreme Court for its contempt 129, similarly High Court for its contempt. With reference to the India, consider the following statements. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from the recognition of advocate. This is with regard to the Advocate Act. Okay. Bar councils have the power to lay down the rules relating to the education recognition of law colleges. 2 is correct. 1 has to be wrong. Advocate under Advocates Act refers to anyone. They are not excluded. Okay, so they also practice in corporate law firms. Okay, but they again are the registered lawyers. They can advocates. They can go to courts. With reference to the Indian judiciary, consider the following statements. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the prior permission of the President. Okay, so again, with the prior permission, yes, allowed. High Court, whenever there is the lack of quorum in the courts, then this particular idea can be practiced. High Court in India has power to review its own judgment as Supreme Court does. Answer is yes. Okay, so it has been said that High Court is also the court of record. Consider the following statements. The motion to impeach a judge of Supreme Court of India cannot be rejected by the Speaker of Lok Sabha as per Judges Inquiry Act 1968. Okay. So the Judges Inquiry Act 1968 actually does not talk about any such thing. If you could remember, in 2018, when Congress wanted to bring the motion of motion of removal against the Chief Justice of India, the Rajya Sabha chairman denied it. He did not introduce it. Wrong. The Constitution of India defines and gives detail of what constitutes incapacity. It doesn't define anything. The details of the process of impeachment of judges are given in Judges Inquiry Act. Yes, correct. If the motion for the impeachment of judges is taken up for voting, the law requires the motion to be backed by each house, supported by majority of total membership of that house, and not less than 2/3 present and voting. Yes, correct. So first is wrong. So that makes 3 and 4. 4 is correct. C is the correct answer. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under 142. It could mean which of the following? Now let us try to understand this question properly. With reference to the Constitution, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions on the powers under 142. The decisions taken by Election Commission while discharging its duties cannot be challenged in any court of law. Supreme Court of India is not constrained in the exercise of its power by law made by Parliament. Yes, obviously. In the event of grave financial crisis, the President can declare financial emergency without counsel from the Cabinet. No, Cabinet has to be consulted. State legislature cannot make laws on certain matters without the concurrence of the Union legislature. Now, which of the following? It could mean which of the following? Obviously, it means B. This is unnecessary confusing question. What they are trying to say is that Supreme Court of India is not constrained to use its power. That means the Parliament cannot constrain the powers of Supreme Court. Who among the following is the custodian of the Constitution? Now, there has been a confusion always that who is the custodian of the Constitution. So, the answer given is D. The Supreme Court of India happens to be the custodian. But if you will see in the Constitution also, the President has been given a duty to protect the Constitution, defend the Constitution. But when it comes to the custodian, so obviously it is the Supreme Court which guards the Constitution. Who has the power to increase? It is through the Judges, Number of Judges Act. Okay. So the Parliament, through the amendment, can increase the number of judges. The power of the Supreme Court of India to decide dispute between center and state falls under which? Between center and state is original jurisdiction. It is the original jurisdiction. Okay. So what will happen under original jurisdiction? Supreme Court, center state on one side, center state on one side, center versus state, state versus state, center plus state versus state plus state. All of them can go into Supreme Court, directly to the Supreme Court. This is called as original, because otherwise you go through appellate. If I want to go, I cannot go directly to the Supreme Court unless my fundamental rights are not infringed. For any appeal, I have to go through the other courts. Next comes judicial review. The power of judiciary to pronounce upon the constitutionality of laws and executive orders is called as judicial review. Question the wisdom of the laws enacted by the legislature. No. The power of judicial review legislative enacted before they are assented. No. This is again separation of power. Article 121, 122. The power of judiciary to review its own judgments given earlier. A happens to be the most valid answer. Okay, so A is correct. subordinate courts. With reference to the National Legal Service Authority, consider the following. Its objective is to provide free, competent legal service to weaker section on the basis of equality of opportunity. Yes, correct. It issues guidelines for state legal service authorities to implement legal programs and schemes throughout the country. Technically, yes. These are again very simple questions. It is about NALSA. Okay, NALSA has these functions. NALSA creates awareness. NALSA ensures free legal justice. And NALSA has been created through the NALSA Act. It's a statutory body. It was first pronounced in the judgment, the NALSA judgment, and Article 39A of the Constitution also talks about free and legal aid as an important DPSP. It was amended, inserted through 42nd Amendment. Now consider the following statements. In India, prisons are managed by the state government. Yes, they have their own rules and regulations in day-to-day administration. Prisons are governed by Prisons Act 1894, which explicitly thus in the control of the provincial governments. So yes, both these statements are correct, but is the second statement the explanation of first statement? Yes. Okay, so both are correct. Yes, explanation is correct. Consider the following statements. The Speaker of the Legislative Assembly shall vacate his or her office if he ceases to be the member of the assembly. Yes. Yes, this is correct. Whenever the legislature assembly is dissolved, the Speaker shall vacate his or her office immediately. No. Continue as a pro tem and can sit for the first sitting so that elections can be announced. Elections can be done. New speaker can be elected. The Legislative Council of State in India can be larger in size than half of the Legislative Assembly of that particular state, not more than 1/3. The Governor of State nominates the chairman of the Legislative Council of that particular state. No. No nomination. He is the member of Legislative Council. So both are incorrect. Governor. It is the governor of state who recognizes and declares any community of that state as scheduled tribe. A community declared as a scheduled tribe in a state need not to be so in another state. Okay, so which of the following is correct? It is not the governor. President, obviously at one place it is not a tribe, then also it can be considered as a tribe. Okay, so president may by who adds in ST, president, who adds in SC, president. Okay, OBC lists are created on both center and state basis. List of the scheduled tribes declared as scheduled in one need not to be so in the other state. That means if someone is a tribe in one state doesn't means not tribe in one state doesn't mean the other state cannot declare him as a tribe. Next comes with reference to the Legislative Assembly of the state in India, consider the following statement. The governor makes a customary address to the members of the house commencement of the first session of the each year. This is called as special address. When state legislature does not have a rule on a particular matter, it follows Lok Sabha rule on that matter. Again, this is very straightforward question. Okay, so does it will follow the Lok Sabha rule? No. So this basically makes the state to have their own rules. No criminal proceedings shall be instituted against governor of state in any court during in the term of office. Again, this is something, a power which has been given to him. Next is the emoluments and allowances of governor of state shall not be diminished during his term in the office. These are again very simple, straightforward questions. Both happens to be correct. So one is with regard to Article 361. Other is written in the governor office in Constitution, that while the governor is in office, his emoluments, his benefits cannot be reduced. The chief secretary in the state is appointed by the governor of that state, by the CM. The chief secretary in the state has a fixed tenure. Both the statements are incorrect. Okay, so there is no tenure of chief secretary, CM appoints him. Okay. Which of the following are the discretionary powers given to the governor of a state? Sending report to the president, imposing president rule, discretionary. This is a constitutional discretionary. Appointing the minister, reserving certain bills is discretionary. Making rules to conduct business of the state government. So again, these are nothing but the constitutional discretionary. Appointing the ministers, no. As per the CM, he would appoint the minister. 2 is incorrect. So that solves the answer 1 and 3. Rules, business of the state government are done by the state government itself in the name of government only. Which of the following statement is correct? In India, same person cannot be appointed as governor of 2 or more states. No, wrong. Can be appointed. There shall be governor of each state. One person can be governor of 2 or more states. Person can be governor of a state and a UT administrator at the same time. Okay. Next, judges of the High Court of States in India are appointed by the governor. The state, just as the judges of the Supreme Court, are appointed by the president. Okay. Correct. No procedure has been laid down in the constitution for the removal of the governor. No procedure on the pleasure. High Court by the president. Fine. Done. In case of UT, having a legislative setup, the chief minister is appointed by the lieutenant governor on the basis of majority support. No. President. Delhi's CM is appointed by the president. Fine. So these are simple questions. The Northeastern Council was established by the Northeastern Council Act of 1971, 72 years. Subsequent amendment. The council comprises governor of the constituent states, chief minister of the constituent state, then the 3 members to be nominated by the president, the home minister of India. For Northeastern councils, home minister is not required. 1, 2 and 3 are more than enough. Governor, chief minister, 3 members. Okay. Which of the following statement is correct as per constitution? Interstate trade and commerce is a state subject under state list. Anything which is interstate cannot be under state list. Keep that in mind. Interstate migration is a state subject under state list. Again, same thing. Interstate quarantine is a union subject under union list. Corporation tax is a state subject under state list. Interstate quarantine is a union subject under union list. Asked in 2024. What is correct? C is the correct answer. Anything which is interstate, the center will have power. Consider the following statements. According to the Constitution of India, the central government has duty to protect states from internal disturbances. Yes. Article number 256, Article number 365, and then ultimately 356. The Constitution of India exempts state from providing legal counsel to a person being held for preventive detention. Yes. This statement is correct. According to preventive detention, POTA, the confession of the accused before the police cannot be used. It can be used. So I guess B. Just a moment. 3 is not correct. Okay. Yes, 2 are correct. Yes, we mark this as correct. This is also correct. This is wrong. So 2 statements are correct. With reference to the schedule areas, the notification of an area as a schedule area takes place through an order of president. Okay. The largest administrative unit forming the schedule area is the district, and lowest cluster of the village is block. Fine. Chief Minister of concerned states are required to submit annual reports to Union Home Ministry for the administration of the schedule areas. No, they are not. They don't require it. So first 1 and 2 are correct. Schedule areas refers to the areas demarcated by the president. So president has power to demarcate schedule areas, district and the block. No, the chief minister concerned is not required to submit any. It is the duty of the governor. Because when president is involved, the duty is of the duty of governor. Which of the following says that governor should be an eminent person from the outside state and should not be a detached figure without intense political links or should not have taken part in the politics. Okay. Sarkaria Commission in 1983 on the office of governor. So first ARC recommended appointment of persons having long experience, non-partisan. Rajbannar committee recommended state that pleasure of governor should be omitted. He should be given a fixed tenure. Then Sarkaria, he should not be having political links, should be an outsider. And National Commission to review the constitution. The Venkat Chalaya Commission, it said that the president should appoint the governor only after consultation with the state government. Done. How many delimitation commissions have been constituted so far? D is the correct answer. 4, 1962, 63, 73, then 2002, okay, 52, 63, fine. So 1952, then 63, then 73, then 2002. Again, this question was asked in 2024. Local governments and municipalities. Local self-government can be best explained. Democratic decentralization. What is local self-government? Is nothing but the democratic decentralization. Is it federalism? Yes, a kind of federalism only where the power has been divided, but it is asking best. So out of all the correct options, it is also the part of direct democracy, administrative, it is legislative delegation. This is wrong. It is not administrative delegation, it is legislative delegation. But again, if you choose the best, if you have to choose the best, this is the best. Fine. Next comes, with reference to the Gram Nyayalaya Act, which of the following statement is are correct? As per the Act, Gram Nyayalayas can hear only civil cases and not the criminal cases. No, Gram Nyayalayas also have power to hear these criminal cases. Social activity as mediators and reconciliators. What is a Gram Nyayalaya? Gram Nyayalaya is nothing but Nyayalaya at the gram level. So it is an extension of the court system. Okay. So when it is the extension of this court system, so obviously it has power to do the both things, and obviously social activists and the local people can be involved. So 1 is incorrect, 2 is correct. The fundamental object of the Panchayati Raj system is to ensure which of the following? People's participation in government, political accountability, democratic decentralization. When we talk about the idea of Panchayati Raj system, political accountability, democratic decentralization is the first thing you can mark out. Financial mobilization was never our concern. Our concern was giving power at the ground level. Political accountability, no. It is the benefit to the people. C is the correct answer. Anti-defection law. Law specifies that nominated legislator cannot join any political party after 6 months of being appointed to the House. The law does not give time frame within which presiding officer has to decide a defection case. Yes, that is why the Supreme Court has said in 2020 in 𝐑𝐄𝐂𝐻𝐿 case that you have to do this in 3 months. But this is a court's judgment, not written anywhere in the Constitution. So first happens to be incorrect. After 6 months, cannot join after 6 months. You have to join within 6 months. So this is wrong. This is correct. B is the correct answer. Next topic is constitutional bodies. Consider the following criteria used for the horizontal text devolution. Now pay attention over here. Horizontal text devolution. What is horizontal text devolution? There are 2 kinds of devolution suggested by the Finance Commission. One is the vertical devolution, that is between center and state, and horizontal means that how much money has to be given to which state. Okay, so among state, how the money has to be divided. So here the horizontal devolution has been accounted on what grounds? Stable government is not an option over here. Okay, So again, remove stable government. Okay. Now, demographic performance. Yes, demographic performance is highly required over here. Governance reforms. No. Forest ecology. Yes. Tax and fiscal efforts. Yes. So only 3. 2 is the correct answer. B. So let us see. 15th Finance Commission. So population, area, income distance, demographic performance. So upon these, the devolution has been done. Next, Attorney General of India and Solicitor General of India are only officers who are allowed to participate in the meetings of the Parliament of India. Clear? According to the Constitution of India, the Attorney General of India submits his resignation when government which appointed him resigns. Not according to the Constitution. The Constitution does not say that when a sitting government goes, the attorney has to resign. Okay, so this is incorrect. Number 1. Number 2 is it is mere convention. So second is wrong. Are only officers which are allowed to participate in the meetings of the Parliament of India. Again, the question over here is that only Attorney General is allowed. Solicitor General is not allowed because Attorney General has been given this power through the Constitution. Attorney General is a constitutional post. Solicitor General has been created through the law officer rules. So it is a statutory post. It is not a constitutional post, and later on the rules were passed. So Solicitor General cannot sit in the meetings. Attorney can sit. D is the correct answer. Election Commission resolve the disputes related to splits and mergers recognized political parties. Which of these statements are correct? I guess this question, there's some error over here. I'm skipping this right now. Consider the following statement. Attorney General of India can take part in the proceedings of Lok Sabha, be a member, not member. Speak in Lok Sabha, yes. Vote in Lok Sabha, no. Again, so this we have discussed specifically with regard to the Lok Sabha. So which of the following is correct? So one is correct. Be a member of committee, Be a member of committee of Lok Sabha, yes. Be a member of committee of Lok Sabha, yes. Speak in Lok Sabha, yes. Can they vote in Lok Sabha? No. So C happens to be the correct answer. Non-constitutional bodies. National Commission Backward Classes, Human Rights Commission, National Law Commission, Consumer Dispute Redressal Commission. Which of the following is a constitutional body? So what exactly are the constitutional bodies? Constitutional bodies are those bodies which are mentioned in the Constitution. So NCBC is mentioned where? 338B of the Constitution. NHRC, statutory. Law Commission, executive. Consumer Dispute Redressal Commission. Okay, so not mentioned. Fine. And here comes another question. Gopalasammy Anger Committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reforms and promoting it. 1970 Department of Personnel was constituted on the recommendation of the administrative reforms, and this was placed under Prime Minister's charge. Usually what happens in such questions, you will find that many times you will find that this is correct, but actually this is wrong. First is wrong, second is correct. Just go through it. This is. So I guess I have tried to cover all the important questions of the previous 10 years. So you can see that what kind of questions have been asked. More stress was on the latter part of the topics. Very less stress on the fundamental rights, but yes, we have to cover the fundamental rights to the fullest because they are very important for the mains. But when it comes to the prelims, they have asked the questions are more from the factual side or they're more from the technical side. So hope this would help in clarifying your further doubts, and this video would certainly help in quick revision of the topics. So I guess, and this is more from my side. In case if you want something else, you can put in the comment section what other kinds of videos are you expecting if you are going for 2026 exam. So see you some other time. Till then, just a final message. Those who are writing prelims this year, do not panic. Just go through the paper thoroughly. Try to read the questions. Answer is always within the question only. And polity is very simple, very straightforward. You just need to apply your mind. Do not get panic. There must be the answer around you only. Just try to find it out. And in case if you are not very certain about the answer, leave it for the last moment. Okay, you can leave it for the second or third half of the paper. Why? Because many times the things are not we are not able to strike the things, the mind is not functioning, but yes, at later stage you would be able to find the answers. So this is all from my side. All the very best to those who are writing prelims, and hope you come out with the flying colors. And those who are going for next year, again, all the best for them as well, so that you are on track and you are able to complete your preparation in the given time. Thank you very much, and Jai Hind.